Okay. Dear, dear, dear participants, dear colleagues, ladies and gentlemen, good morning. I'm Stefano Bartolini. I'm the director of the Robert Schuman Center, and it is my pleasure to welcome you at the European University Institute for this forum on regulatory and legal energy issue. I would like also to bring to you the salutation of the president of the UI, Professor Maris Cremona, who could not be with us today. Let me extend my thanks not only to the participants, but to a number of people who have made this conference possible, which is always with us. First of all, Lee Hancher, who is usually the responsible of our, let's call it, legal module or regulatory module. Jean-Michel doesn't need to be thanked because he is the pillar of the entire building, but I would like to thank our sponsor, our donors, and I would like also to thank BNetzAgentur, with whom we jointly organize this event. Let me begin my short welcome or introduction with the bad news. This room is not air conditioned, which means that you have to go through a painful day of suffering at this stage of the year. We already had a very hot summer, and the heat gets into the old walls of these villas, and once the heat gets in, there's no way to get rid of it. So be prepared for that. When I welcome participants to the Florence School of Regulation activities, I'm always extremely embarrassed because I never know how many of you are here with us for the first time. I mean, we have a certain amount of people who happen to repeatedly appear and they already know everything, and people who are always new and know nothing, and they would like to know something perhaps about the UI and the Robert Schuman Center, the framework within which the activity of the Florence School takes place. But this time I see that there are 4 introductions, and 4 introductions without air conditioning are too much. Therefore, mine is going to be pretty short. I'll simply make a few words about the Robert Schuman Center, within which, as I said, the Florence School organizes activity. We are rapidly becoming a center for the analysis and evaluation of European Union policies in various sectors. You know the activity of the Florence School, I'm pretty sure, and if you don't know, you will be reminded soon by the other introducers. But I would like to inform you that the same kind of activities which are performed in the field of the network market regulation are done at the Robert Schuman Center in many other fields, and we accumulate slowly the position of being, perhaps, I'm immodest at this stage, the most important European center for policy analysis in the field of European integration. Certainly, I should mention that only a few days ago, at the presence of the Commissioner Malmström, we have opened, after several years of work, a migration policy center, which will be devoted entirely to the analysis of the migration policies of the EU. We have done the same in the field of media. We have a similar program in the field of global governance issues, those kind of issues that go even beyond the regional integration problem. We are active in the field of development, where we were given the task by the Commission to write for a couple of years the European report on development of the EU. And we have several other units of policy research, applied and policy research. And all these activities are performed with a single philosophy. They have to be problem-oriented, not disciplinary-oriented. At the UI, there are disciplinary-oriented activities. As you know, there are departments, there are PhD students, there are teaching, supervision, the usual stuff that a university does. The Robert Schuman Center is not doing this stuff. It's doing policy research, applied research, policy-relevant research, which has to be, therefore, problem-driven, interdisciplinary, and continuously in a situation of dialogue with the practitioner and with the stakeholders. And this model is applied in every sector in which we move. We try to combine academic excellence with a dialogue with the stakeholders and an interdisciplinary approach. Having given to you a very rudimentary introduction to this place and to this institution, I'll simply again wish you a not too hot and profitable working day, and I pass the floor to whom? To Lee, following the list. Thank you very much for coming.
Thank you indeed, Stefano, for welcoming us and giving us the background to the many activities going on at the Schumann Center at the university. So my task is to introduce this morning's and this afternoon's event. This is our third collaboration with the Bundesnetzagentur, where we have been able, I think, to establish already a tradition of looking at topical, complex regulatory issues. And you'll see on the program today, we're devoting a lot of attention to the subject of certification. And I think probably we're one of the first conferences that have been able to put this item, not only put it on the agenda, but devote much of the day, or at least the first part of the day, to it. And when I try to explain to people what this is all about, I try to use the analogy of a game of Monopoly. If you buy a house on one country, that means you have to be careful where you buy a hotel in another country, because you have to think about this as a strategic game. But last week I found a new concept like Monopoly, but this is called Confusopoly. And I think we're heading very quickly into an area of Confusopoly, and I hope that you'll leave today feeling confused at a higher level. Then we really have achieved something. So like Stefano, I want to keep it short because it's very warm already and it will only get warmer. So I would like to just quickly hand over to Jean-Michel Glanchon to say a few words about the Florence School of Regulation. Thank you, Jean-Michel.
Thank you, Lee. We are now 8 years old. We are too big to be introduced, too big to be summed up. So you have a folder, you have a website. I can only give you one number, which is not in the folder. We are now 50 people with labor contract inside the UI, plus 12 people with being external collaborator, having no seats, like Lee, which is standing up in front of you. And these people are working for a third in telecoms, media, and transportation, and for 2/3 in energy. Hallelujah, enjoy the day and deal with the heat.
Just to conclude very shortly, also from BNetzA part, thank you very much to be here. We are very pleased to welcome you here to the workshop. A workshop that we are organizing now since 3 years with the Florence School of Regulation, an excellent collaboration with the Florence School. That's why I wanted to thank also Lee Henter and Adrien for the excellent organization. Perhaps just one word on the agenda. You will see that this year we are not focusing on the implementation of the third package, but we try to extend the discussion to new sectors like the one coming from the infrastructure package and the remit. So I think there will be new discussion, new issues to discuss today, which will make the whole thing a little bit more interesting, probably. And finally, I wanted to thank also our former Vice President, Johannes Kindler, who is here today, exceptionally, because he made it also possible for BNetzA to participate, or to co-organize this workshop during these 3 years. So also thank you very much for the support. Thank you.
A bit of musical chairs this morning, but Jean-Michel hasn't started singing yet. You might have to. So I'd like to hand the session now over to Christopher Bremme from Linklaters, who will chair the whole of the morning session. We're very pleased to have him here. And unfortunately, we don't have any CVs, so we're going to just allow people to very shortly introduce themselves, say a few words. Thank you.
Yeah, good morning. My name is Christopher Bremme. I'm a partner with Linklaters in Berlin, active very much in the energy field and in particular also on unbundling issues, because that is an issue that's quite close to the heart of our clients. We're now sort of in section 1 of our session. This is unbundling and the certification of TSOs, state of play and critical issues. First, we will hear the views of the regulators from Germany, Sweden, and Italy. And we will start, I don't know.
I guess I will start.
Yeah, and Johan Ruppe from the Energy Markets Inspectorates in Sweden will start and give us the Swedish view.
Well, good morning to you all. My name is Johan Ruppe. I come from the Swedish regulator, where I work as a senior legal advisor. I've been directly involved with the certifications of, as we thought, 2 very easy certifications, because we saw ahead just one for gas and one for electricity. And along the road, of course, we discovered that we may have 2 more potential TSOs, because as you may know, we have 2 standalone merchant cables, one from Sweden to Germany or from Germany to Sweden, called Baltic Cable. And in the east, we have one standing alone, still standalone cable between Sweden and Poland, or Poland to Sweden, called Swepo-Link. And that's a topic we may address in the discussion further, whether these should be certified at all, or if so, what should the implication be if they are certified. We have an example that I will touch upon from the UK, or GB, where they have similar things from the offshore wind farms, but they have decided that they should be certified, but not be part of NSOE and so forth. So this is a slide that I have stolen from my colleague Johannes Meyer of Austria, because he was supposed to give a presentation but is unavailable to come. And this is an overall slide to give you the timeline, how it's supposed to happen, the certification. And as you can see, it either can be, if the member state is silent, so to say, it can be a request from the Commission itself, or the TSO itself, which will be the normal, that they approach the NRA, the National Regulatory Authority, with a notification to be certified. This whole procedure is supposed to take 4 months, but at least for us in Sweden, we started it, and almost a month in, the Commission summoned all the member states and realized that they may have certifications coming in strange languages like Swedish, Lithuanian, or Hungarian or something that they may not be able to read directly. So then they developed a questionnaire which they politely asked everyone to fill in English and hope that so will be done. So we had to come back to our applicants and give them this questionnaire, and from one of the TSOs, they were rather upset with this and said that this was not in the regulation or in the directive, and why should we fill in this? The 4-month period has already started, while we said as the regulators that well, the 4-month period starts when we deem the file to be complete. And as you may very well know, the Commission and especially the National Regulatory Authority can ask whatever it needs information for the certification. So in their overall view, eventually they came around and realized that this was not something they will gain anything from fighting. So the overall legislation, I will go quickly through this, is of course given in the regulation both for electricity and gas, and it's Article 3 in each one of them. Then when you come to the really interesting part is of course the different types and what can be within a TSO to be certified either as an ownership unbundled one or an ITO, independent transmission operator, or independent system operator. It comes, the details are given in Article 9 in each directive. And here, of course, it's up to the member state to decide which one or all of these that it wants to implement in its national law. For instance, in Sweden, the legislator has opted only to allow ownership unbundled in electricity. And in addition, of course, the national legislation is written in a way that ties the hands of the regulator. I can only certify Svenska Kraftnät, which is the transmission owner on land, at least in Sweden. But as I started out, we have these two cables that may or may not also be still standalone cables that should be certified. But at the moment, I as a regulator cannot certify them. Now if you go across the Baltic Sea, you have Germany on the other side, and they have implemented all three options. So if you take Baltic Cable, for instance, as an example, they could then be certified in Germany as an independent transmission owner or independent system operator. They cannot be certified at the moment, at least, due to the owner structure as ownership unbundled, because they are owned by the largest generator in Norway. Now, in Article 6 of the directive, both in electricity and gas, you have that state-owned TSOs, or it doesn't say state-owned, it says publicly owned, should be deemed as two separate entities. But at the end of the day, of course, even if you are publicly owned or state-owned, you still have to adhere to the same criteria as if you are privately owned. That is that you have to make sure that you don't have connections between generation and trade and the operation of the transmission grid. And in the case of Sweden, of course, Svenska kraftnät is a very Swedish character. It's part of the state, and in some aspects it's also an authority when it comes to technical issues and security standards to be connected to the transmission grid. They have the power to issue regulations and decrees on the standards to be adhered to be able to be connected to the transmission grid. And of course, in the actual performance of operating the grid, they are deemed as an entity which falls under the IE, the Energy Markets Inspectorate. Now, in the Swedish Constitution, we have that a minister may not interfere with an authority's operations, daily decisions and so forth. And as you may well know, the state also have a totally state-owned company called Vattenfall, who is engaged in generation, trade, and distribution of electricity. So the Commission, of course, were a bit concerned that, well, maybe I should start with that. Luckily enough for us, they have been a bit foreseen by the Swedish legislators, so in that sense that Vattenfall is put under the Ministry of Finance, and Svenska kraftnät is under the Ministry of Industry. And no one from the governmental offices are present in the board of Svenska kraftnät. So there's no governmental official in the board, which there were 5-6 years ago. So that's very clean cut in that sense. So it's all third parties, no one from the industry. It's professors of economics and other fields, and of course people from other sorts of business in society, but not in energy. However, the Commission raised in its opinion that you can read on the homepage, of course, concerns that in the long run there may be problems or interference by some minister, especially the Minister of Finance, since he's in charge of Vattenfall. And of course, for us as the regulator, we try to explain that we have in our constitution that no minister of any kind, or for that matter, the Prime Minister, can interfere with the daily decisions or the decisions at Svenska kraftnät. And in addition, of course, we have implemented more or less letter by letter directly from the directive that you may not have anyone involved or in influencing trade or generation or so forth on the board or as a CEO or something. So we haven't taken the final decision yet, but we are about to any day, hopefully tomorrow at the latest, where we will argue this, and of course then we have to publish this on our homepage together with the opinion from the Commission, and then of course literally send our final decision to the Commission. And then it's of course up to the Commission to scrutinize this and if they will come back to us or not. To put it in a bit of perspective, the ones just before us to talk to the Commission were the Danes, and in contrast to us in Sweden, they don't have in the constitution that minister may not or are strictly forbidden to interfere with state authorities and so forth. So they, of course, had to come up with legislation to put so-called Chinese walls around the Minister of Energy and the Minister of Finance. So, of course, that's very concrete and very easy to understand for the Commission. And then you have this little country from the north coming saying we have in our constitution a fundamental prohibition against this, and then in addition we have literally letter by letter replicated in our national legislation all the requirements. So we will see what happens. When it comes to our TSO in gas, it was just before or the year before we were due to certify them, sold to a risk capital firm in Sweden with several, of course, offshore companies via the Netherlands and Channel Islands, and ending up eventually mainland England. Luckily in the end, because at one stage, if they were based on the Channel Islands, if the control was with the entities based on the Channel Islands, we were facing a third country certification, which is in the reflection, of course, wouldn't have been so bad, because then we could have waited to 2013 instead. But at the end, they showed and convinced us and the Commission so far, at least when reading their opinion, that the control is held by an entity based in England. So it was within the Union. And there, of course, being a risk capital, it has a portfolio, of course, of several investments. And in these investments, there were assets in the United States involved in gas storage and gas production and also electricity. No, not gas production, just gas storage, but production of electricity. And of course, if you read Article 9 in the gas directive, or even the same as in Article 9 in the electricity directive, you may not own any production sources whatsoever. So we approached the Commission, of course, and said, we read this, and if you read it literally, of course, they have to divest saw was, of course, that this geographically was located far beyond any influence on the European and especially the Swedish activities. And the Commission, if you read the opinion, of course, you see that they accept this. In addition, of course, they owned they own a waste management company in Denmark, and it comes out as district heating. But of course, in the summer months, the demand for district heating is not very large, so then it comes out as pure electricity. But there we argued what I put here on the slide, the fair util, that the purpose of this company is not to produce electricity, the purpose is waste disposal. And in addition, there is a very strict Danish legislation how this electricity should be sold. It has to be sold on the no pull spot, and it's a fixed price. And if they don't achieve that price, if the Danish TSO has to reimburse them. But if they achieve above that price, they have to send the surplus to the Danish TSO. And it all comes to the last bullet point, all these problems that I tried to describe. There is no de minimis in this legislation, which you can see in especially competition law. Normally you have de minimis, at least in antitrust, and more or less indirectly now in state aid as well. I mean, that's the problem, that there is no leverage if you read strictly the directive to make deviations.
Okay, thank you very much for your questions. Let's move on to the Italian view. Chiara Petruzzo from the Italian regulator AEG.
Thank you. Thank you to the Florence School for inviting me, and to BNetzA for inviting me to speak today. I work in the legal department of the Italian regulator, and I'm not new to the unbundling subject, as I've been dealing with this implementation of the second package and the functional unbundling rules. But today I will speak about the certification procedures, and in particular the ITO model, which is to date the only model pre-certified in Italy. The rules on unbundling of the package have been put in place by the Italian regulator through a resolution adopted on November 2011. This resolution sets the general legal framework for certification procedures, no matter the unbundling model to be implemented. The resolution contains general rules for each model, but in Italy only two models are to be implemented: the ownership unbundling for the transmission system operator and the ITO model for the gas transport operator. as the Swedish regulator, we have accompanied these general rules with questionnaire to be filled in and sent back to the regulator by the operators that need to be certified. Then, within 4 months after receiving complete information, the regulator adopts a pre-certification decision, which is notified to the European Commission. And there has been a problem because not all operators have sent complete information at the first time, so we were burdened with asking more information in order to have the complete scenario. As I already mentioned, up to now, only the National Transport System Operator, SNAM-ReteGas, has been pre-certified, and the decision notified to the European Commission. We have not yet received the opinion from the Commission. The Commission has 2 months to deliver its opinion, and after that, the regulator will adopt the final certification decision. The resolution on November 2011 adopts a definition of vertical integrated undertaking, which is in line with the interpretation given by the European Commission. That is an important point because the European Commission gives a broad interpretation of VIU, not limited to the electricity and gas sectors. And the importance of this broad interpretation is that it allows to achieve the ultimate goal of unbundling. And another point, which is important to us, very important to us for the implementation of the ITO model, is the categoric prohibition of any commercial agreements between the VIU and the ITO company. And also on that, the Italian regulator was very strict, in line with the interpretation given to the from the European Commission when implementing the ITO model. As I said, currently SNAM-ReteGas is the only pre-certified operator. SNAM-ReteGas is under the control of SNAM SPA, which has 3 other subsidiaries, all operating in regulated sectors. And the group is a combined system operator, which is under the control of the VIU ENI. But the only company which is certified as ITO is SNAM-ReteGas, that operates almost 96% of the Italian transport gas network. Between the SNAM SPA group and the VIU, there exist rules of separation and independency, which are in line with the second package. Rules of functional unbundling are applicable between the group SNAM SPA and the VIU, whereas rules on unbundling from the third package are applicable to the ITO companies, SNAM-ReteGas, and in relation with the VIU ENI. So the ITO company has stricter rules on unbundling, but still the SNAM group, the combined system operator, is separated from the VIU thanks to functional unbundling rules. I won't recall all the rules applicable to the ITO model here, but I want just to highlight some challenge that we have encountering during the certification procedure. One of that was the implementation of the governance of the ITO company. The European directive imposes the setup of a supervisory body which is responsible exclusively for decisions which have an impact on the value of the assets of the shareholders. Members of the supervisory body, according to the European directive, do not have any role in the management and in the business of the ITO company. The IG took the view that the so-called traditional model of company is also applicable to implement the ITO model, and as a result, the supervisory body is set within the board of directors, performing only the tasks that the directive give to members of the supervisory body. Those rules separating the tasks of the rest of the members of the board of directors and members of the supervisory body are inserted into the company statute. We have also put attention to the respect of independence requirements between the members of the supervisory body and members of the board of directors. And this is an example of the structure and of the governance of the ITO company. So the supervisory body is set within the board of directors, but refrains from any decision linked to the management and to the business of the company. Another important point, as already mentioned, was the prohibition of any commercial agreements between the ITO and the VIU, and the Italian regulator allows for certification only when that requirement is complied with. Even in informal contacts with the European Commission, we have been very clear on that, and the Commission as well. So also in the pre-certification decision, that was a clear requirement to the company to be pre-certified. So the pre-certification decision of SNAM Retegas was adopted by the regulator on 18 May 2012 and forwarded with relevant information to the European Commission. The company has been pre-certified with commitments and a deadline. Indeed, we had in mind, while pre-certificating SNAM Retegas, the process of transition to full ownership unbundling. A law adopted in March 2012 has imposed the complete full ownership unbundling of the SNAM group from the VIU ENI. So having that in mind, the Italian regulator took a flexible approach when adopting the pre-certification decision, and has imposed commitments to the ITO company to be complied with within a deadline. The deadline corresponds to the date by when the SNAM group will be completely ownership unbundled, which is September 2013. So among these commitments, we have requested the insertion in the company statute of specific provisions imposing the compliance with the rules of the resolution, the acquisition of portions of network not yet owned by the ITO, and so on. The flexible approach, the flexibility, is meant to be only with regard to the time frame of implementation of these commitments by the ITO company. By that date, by September 2013, either the ITO company will be fully ownership unbundled from the VIU as the law imposes, or will be fully compliant with the commitments imposed by the Italian regulator in the pre-certification decision. And yes, that's all. Thank you.
Okay, so first we will have the view from GRT Gas, which has been sort of the object of a very extensive opinion from the European Commission. And I ask Claude-Albane to start.
Thank you. Good morning. My name is Claude-Albane. I work in the legal directorate of GRT Gas SA in France. And I'm going to take you through the certification of GRT Gas. The certification procedure has been completed, and we received a positive certification decision by the French regulator on the 26th of January this year, 2012. First, I'm going to try to provide you with an overview of GRT Gas, who we are, what we do. Then I'll provide a brief description of the French transposition and certification framework to put things into perspective. I'll focus afterwards on the content of the certification procedure, and more specifically on the governance of GRT Gas, on the autonomy of the TSO and its independence from the VIU, and on the role of the compliance officer, because this is where the impacts have been. And I'll try to highlight the practical issues we've been faced with and the solutions we provided with the regulator. And at the end of my presentation, I'll say a few words on GRT Gas interests in Europe, because we have recently acquired some shareholdings in transmission system operators in Europe. And for this reason, we're following with great interest the certification procedure in other countries. So first of all, GRT Gas. GRT Gas was created on the 1st of January 2005 as a wholly owned subsidiary of Gaz de France. Now it's the group GDF Suez. January 2005, it was the implementation of the second package and the legal separation of transmission activities from supply and production entities. Today, our shareholdings has changed, and GRT Gas is owned still by GDF Suez, 75%, but also by the SIC consortium, 25%. The SIC consortium is an investment vehicle owned by the French state, and actually it's recent that this market opening took place. It happened last year, about a year ago, July 2011. Our main mission is to transport the natural gas needed by the French gas distributors and by the industrial plants that are directly connected to our network. We operate, maintain, and develop our network in the best conditions in terms of security, reliability, and cost. And indeed, we have public service obligations that are placed on us by the law. A few figures. Our network is roughly 32,000 kilometers long. It covers 85% of the territory. We're one of the 2 TSOs in France. The other TSOs covered the 25%, the rest of 25% in the southwest of France. In 2011, we transported 639 terawatt hours of gas. We have 26 compression stations, 89 gas shippers, 3,000 employees, and our revenue for 2011 was 1.5 billion. Our network is connected to several LNG terminals, 3 LNG terminals. Some additional connections have been recently decided with Spain, Belgium, and an LNG plant also in Dunkirk. Investment for 2012, 764 million, and 8 billion for the next 10 years. The French gas market, the structure has evolved in the past few years. We went for many balancing zones to 3 today, 2 for GRT gas, north, south. So there has been quite a bit of work with the regulator. And as I said earlier, we have 89 shippers. So here's an overview of our client base. Very quickly, the steps for the certification procedure. It started in May last year, about a year ago. CRE issued a deliberation setting out the steps of the main steps of the procedures, and also the list of documents to be provided as part of our file of our request for certification. In September, CRE also set the deadline for filing for certification, the 6th of June 2011. So I believe in France the timing is a bit ahead. It's set in the law, actually, in the French Transposition Act, that the certification procedure needs to be completed by the 3rd of March 2012. I believe the directive allows for different interpretations, and that's the interpretations that has been retained by the French legislator, and therefore that has been applied by the regulator. So the first decision, pre-certification, if you want, was passed by CRE on the 15th of September 2011. On the 9th of November, on the 27th of November, the Commission published its opinion. It's available on the website. And on the 26th of January of this year, CRE issued its final decision certifying GRT gas. A brief word on the transposition framework, the main provisions of the French Transposition Act. The directive has been transposed into French law through an ordonnance in May 2011. And it's been codified as part of the French Energy Code, which is very helpful. Now we have all the text on energy in the same code. The view that has been taken by the French legislator is that existing TSOs, meaning where the transmission system belonged to a vertically integrated undertaking on the 3rd of September 2009, when this criteria is fulfilled, then the TSO must comply with the ITO model. In fact, this concerns all 3 existing TSOs in France, the electricity TSO, RTE, but also GRT gas and JIGF in gas. The definition of the VIU, in the previous presentation we heard the view of the Italian regulator. The French legislator retained a definition which is a bit more narrow, where a gas TSO is controlled by an undertaking or undertakings controlling also gas supply or production undertakings, then we are in the presence of a VIU, and all these undertakings are considered as being part of the VIU. It seems restrictive at first sight, however, and as I will explain that later in my presentation, in practice, it's not at all circumventing the directive, as we'll see, for example, for commercial financial agreements. All financial and the law is actually broader, so all commercial financial agreements that are signed between the TSO and undertakings control by the VIU, they need to be submitted for approval to the regulator. And that's the same for cooling off, cooling on clauses. In fact, in practice, it's quite broad. I've already, new TSOs. If ever there's a new TSO in France, probably there will be in the future, we don't know. They must comply with the ownership unbundling model. I've already talked about the timing. The French Transposition Acts contain some provisions on the certification of third countries. However, this is non-applicable in France for now, at least for now. So really the unbundling issue was the really bulk of the transposition in France. However, there are other interesting provisions in the French Transposition Act, mainly regarding the powers and duties of the regulator. I'm coming now to the content of the certification decision of GRT gas. Governance first. There has been really a strong impact on our governance, and in fact, during the course of the certification procedure, we changed our bylaws twice. We changed them first when we presented our file for certification to the regulator, but also during the certification procedure in order to address some of the concerns or some of the issues that had been raised by the European Commission. The main issue here is that the ITO is the only model where the TSO is controlled by the VIU, and that's the essence of the ITO model. That's important to remember it. But certain provisions of the ITO model, which are very detailed, they may conflict with certain basic provisions of company or even labor law. So we had to find a fine line between these two conflicting, if you want, demands. So one key area of focus has been the remit of the board of directors. As the Italian colleague, we have the one-tier model for our governance. This is not impacted by the implementation of the directive. However, the directive, it establishes a very strict distinction between what's within the remit of the board of directors and what's excluded from the remit of the board of directors. So under its remits or decisions, we may have a significant impact on the value of the assets of shareholders, including needs the board of directors deciding on the amount of dividends to distribute it to shareholders. So that's something that's a bit unusual in company law. So there has been a discussion between us and the regulator in the course of the certification procedure. And so the solution we have found is that the shareholders meetings makes a proposal, but it's really the board of directors making the final decision in the end. It needs to be very clear that certain tasks are excluded from the remit of the board of the directors. It's everything that relates to the day-to-day activities of the TSO, and also those in relation to the activities necessary for the preparation and implementation of the 10-year development plan. So these decisions, they're really exclusive competences of the management of the ITO. Note that, and that's actually taken from the French Transposition Act, it goes even further than the directive, because the directive doesn't prescribe that also activities necessary for the implementation of the 10-year development plan are excluded from the remit of the board of directors. But that's the way it's been implemented in France. In fact, and just to give you a bit of background, in France, the approval of investment was already, even before of the transposition of the third directive, it was already approved by the regulators. So it's never been really completely within the scope of the board of directors. Our regulator, approves every year the investment program of the TSO. I know that's not the case everywhere else in Europe. But Krona has additional powers to consult on the 10-year development plan and to take certain measures, of course, if an investment that was foreseen in the 10-year development plan is not executed. So in practice, you can find our 10-year network development plan on the website. Actually, it's the sixth year that we've been publishing a 10-year development plan, but obviously with the new procedure, it's the first exercise. Also, another issue that has been discussed during the certification procedure between the European Commission and between the French regulator, is that our board of regulators, our directors retain certain competences for approval of investment above a certain threshold. I want to clarify that these are not investment in infrastructure, These are investments that are other than those foreseen in the 10-year development plan, so this is really a strict division here. Also, the threshold is actually quite high, it's 50 million euros, so it's not small investments. Still in the governance area, we had to implement the cooling on, cooling off rules, which are, a novelty of the ITO model. The French Transposition Act actually clarifies, which is helpful, some provisions of the directives. For example, it clarifies what is the executive management, what is the management, who are the management person directly reporting to the executive management on core transmission tasks. In practice, during the certification, as part of our file, we presented the regulator with a list of board of directors members, half minus one, who would be concerned by those rules, cooling on, cooling off. We did the same for the executive management. A practical problem we've been faced with is, as part of our board of directors, some of the members of our board of directors, they're actually elected by the employees, by the Works Council, and they've already been elected, so it was a bit difficult to apply to them the cooling on, cooling off clauses. So we made a commitment to the regulator, and it's been accepted that we would change the rules of procedures for the elections of these directors. Actually, the next election is in 2013. So we will change the rules so that the next directors that are elected by the employees that these cooling off, cooling on rules are applied to them. They have, with regard to the prohibition for all employees to hold any interest of the VIU, the directive is quite clear, the French Transposition Act as well. What we did in practice is that we formally wrote to all our employees in order to ensure that they were aware of the new legal prohibitions. Also, new recruits, evidently, they received the information. There was an issue with the senior managers' careers. Senior manager, not the executive management, but senior managers, as is often the case when you have a group, career trajectory. there was an opinion before that was requested from the VIU with regard to the remuneration of such senior managers. This is not in line with the third directive anymore. Therefore, the VIU is not informed directly. Now there's a simple communication to the shareholders meeting. That's something that has been raised in the Commission's opinion, and that has been implemented. This is a bit on the side, but in order, I'm not going to say to compensate, but now our staff did not allowed evidently to acquire any interest in the VIU. However, we have opened our capitals to our employees, and we have launched a new program, and that they own 0.13% of the capital through a fund. I only have 3 minutes left, so it's going to be, it's going to be difficult. Autonomy of the TSO. I mean, it's mostly on my slides, but one point that I'd like to stress is that ownership of the transmission assets is not an issue in France. I know that it's an issue in other European countries, but in fact, we own our network in the sense of the French Civil Code. Autonomy of human resources hasn't been an issue, much of an issue either. A few adaptations that we have done. And we believe that now we are fully compliant with these requirements. Separation of IT, probably that's been the most difficult thing to implement. The directive is very strict in this regard, and so is the French Transposition Act. I'm not an IT specialist at all, but the fact is that certain services, softwares, they have been run for many years by GDF Suez for GRT gas. What we have done is that we have prepared a roadmap and presented it to the French regulator. This roadmap ensures that IT are fully separated by 2014. The Commission was a bit concerned that it was too far in time, and especially from the point of view of the protection of commercially sensitive information. The European Commission has raised some concern. However, with the French regulator, what we argue is that it's really significant efforts. We need to create an additional 30 to 50 posts. It's 46 million euros of investment. So in its final decisions of certification, CRE has actually cleared our roadmap for 2014. Commercial and financial agreements, rendering of services. I just want to make the point here that in the directive there seems to be a different regime between commercial and financial agreements that needs to be submitted for approval to the regulator when rendering of services from the VIU to the TSO is strictly prohibited. So what we did with our certification is that we put our contracts on the commercial and financial agreements box or on the rendering of service box. Evidently, services contract form also part of the wider scope of commercial and financial agreements. In practice, it's something that has been difficult to implement because certain services we need from the VIU that has to do with the structure of the market. You know, I take an example. We need to swap L-gas contract from our VIU, and that's because we have a small L-gas network in the north of France. So there have been some cases, and it's not really conflicting with the independence, where it's very difficult to get rid of, to put an end to these services. The French Energy Code actually has set out the criteria, list the criteria, and is allowing as an exception certain services. You know, provided, you know, if certain interests, superior interests, meaning security, safety, balancing of the networks are at stake. This has been actually more or less confirmed by the European Commission in its opinion. And in fact, it has added to the list, you know, it has admitted that some services may be needed, if they're strictly necessary for the network, if there's no alternative provider for these services, if they're rendered under normal market conditions, of course, and if they are limited in time in principle. So CRE, after receiving the opinion by the Commission, has looked at all these contracts, has accepted, cleared certain contracts, has refused, not approved other contracts. So of course we have terminated this contract. Compliance officer, you know, it wasn't really difficult to implement. It was more the novelty, and we thought we have given a lot of thinking to this new function. Now we have a solution. It's someone who's internal, who's full-time, who used to work especially with the protection of commercially sensitive information. So he knows very well the company. He's also quite sensitive to these issues. He drew a list when he first was appointed of all the meetings he wishes to attend, and in practice he attends to all these meetings. He also has regular contacts with the regulators. So far we think it's working well. Last but not least, I want to say a few words about our European interest. Because the opening of the capital of GRTGAS, which I mentioned earlier at the beginning of my presentation, it has coincided with the restructuring of GDF Suez transmission activities in Europe. In December 2011, the holding subsidiary GRTGAS Development SAS has been transferred formally to GRTGAS. In February 2012, the reorganization was completed, and we now have shareholdings through GRTGAS Development in GRTGAS Deutschland in Germany, which in turn has shareholding in the Megal companies, and we also have a 34% stake in BOG in Austria. So this reorganization is not required strictly sensu by the directive. However, it's consistent evidently with the spirit of the directive and the separation between transmission activities on the one hand and supply production activities on the other hand. Evidently, we've been looking with great interest at the certification procedures, especially in Germany and in Austria. I won't be able to comment because these are ongoing, you know, and we're actually expecting these days the first decisions by the concerned regulator. What we have observed, though, is that the TSO really are in a very diverse situation. We've really appreciated the publication by BNetzA of a advice paper in January 2012, which is very helpful for, you know, regulatory certainty. One of the issues that we have raised is, you know, we feel that where an ITO is owned, you know, by a certified ITO, it should not be considered as a VIU. If you look very formally at the way the directive is written, there's sometimes a bit of a confusion between VIU, mother company. Evidently, what we're talking here is horizontal cooperation, not vertical cooperation.
Thank you very much. First of all, I would like to thank the organizer for inviting us to this forum. I must confess this is the first time that I join you here in Florencia. So my purpose is to share with you my experience, my professional experience as a legal director for Enagas. I've been working for Enagas only for 1 year, 1.5 years. So it means that this certification process has in a way overlaps, you know, the time I've been working for Enagas. So the time I joined Enagas, the issues, the certification issue was one of the key points, no, at that time. So let me share with you my professional and personal experience, and I would do it. I try to do it in a quick way because I see that we are already running out of time. Okay. So first of all, I will just try to show you who we are, who Enagas is in the Spanish natural gas sector, and then I will briefly explain you our certification process and the issues and the problems we have found throughout the process. Okay, the first thing I would like to show you is who we are. Okay, Enagas is the owner of the, I could say, nearly the 90% of the transmission network in Spain. We've been behaving as a transmission system operator since 2002. In 2002, we were segregated from a vertically integrated group, which is Gas Natural. Since then, we've been behaving as a transmission system operator, operating, maintaining, and developing the national, well, the natural gas grid in Spain. Okay, in 2007, something happened because the legislation was amended, and because of that, the ownership structure of the company dramatically changed. As you can see in this slide, the change reflects the voting rights and the stakeholding structure of the company, and because of that, in 2007, we became an independent and a real independent company. As you can see, the only legal person which could become potentially the owner or get the control over the company would be the state through the public corporation, which is SEPI. Secondly, none of our private investors could get up to 5% of the stake, equals 3% of voting rights. And thirdly, for those companies operating in the natural gas sector, they only can get up to the 5% of the stake of the company, equals 1% of voting rights. It means that those companies operating within the gas natural sector could not get more than the 5% of our company and would not get more than 1% of voting rights. What is more, those companies cannot join these stakes in order to get more voting rights or more political rights within the company. Okay, because of that, I must confess, as a newcomer in Enagas, that the feeling that the Enagas employees have is the way that they really feel as an independent company against not competitors, but the users of the network. It means that we see that the feeling that my colleagues have at the company is something that our director of regulation always says, like saying that the third package did not affect our lives because we were already in line with the third package. Since 2002 and since 2007, we were already a transmission system operator, and the provisions and the third package for the ownership and bundling model were already in place for us. Okay? So this is the reason why we have the feeling that before we talk about this functional and legal unbundling, then now we talk about this effectively separation or this unbundling model applicable under the third package. But we have something that we use in Enagas, which is which is more important, which is the mental unbundling. So it means that for Enagas, no matter what the third package says, we are already an independent company. Okay? And in this context, I joined Enagas 1.5 years ago. At that time, the certification for the TCO was a key point because we were in a hurry, and we wanted to get the diploma from the European Commission because we were already done at that time. So I'm going to explain you briefly the three phases we faced at that time. Firstly, well, we just meet in order to see how can we get this certification from the European Union and the Commission and then from our national regulator. And at that time, we didn't see a substantial problem or issues with the application of the third package. But what we found was a formal problem, because at that time, in 2011, the third package was not transposed into the Spanish law. So what we had to do at that time is to verify that the Spanish Parliament will not pass the bill, which was at that time at the Parliament. So once we verified that this bill was dropped because the new the general elections was called, we decided to submit the application before the national regulator by saying that, in our case, the only option applicable under the third package was the ownership and bundling model. Why? Because we were already a transmission system operator under such model before 2009, meaning that no matter what the Spanish legislation would say at that time, because the directive would be directly applicable to us. This is what we did. We applied, we submitted the application before the national authority, and afterwards the third package was implemented by our legislator. Okay, this is the first formal issue that we had to cope. That was not a substantive one, but this is something that can happen, no? Within the companies. The second phase was the adoption of the decision by the national regulator. We got the decision at the end of April 2012. It was a kind of conditional decision because even though we thought that we were a full unbundling, ownership unbundling model company, our regulator found two tiny things to be correct for us. One of them was the fact that we have, and we do have nowadays, some of our members of our board who also hold the same position in companies performing some of the functions on the supply and production field. Because of that, we've been asked to correct that situation. Secondly, our regulator pointed out that we also have some of our investors, as you can see, two of those having 5% of a stake, two of them exercise voting rights in companies operating in the production and supply sector, while they do have the right to appoint members of the board in Enagas. Because of that, we have also been asked to correct this situation. Afterwards, 2 months later, at the end of June, the European Commission adopted its opinion, fully supporting the decision adopted by our regulator. It was a short and brief decision, because in fact there was nothing that they could add. I mean, they just confirmed the two conditions set out by the national regulator. So this is what we have nowadays. And now, finally, I just would like to comment what can we do, okay? Because now, as a private company, we have the issue for us in the legal department to tackle this situation, because we have no clues from our regulators nor from the European Commission. They have only said that we have two things or two conditions that we have to tackle, but they don't know, they haven't said us what we may do, because I have already seen in the presentation held by my colleagues that in one of the cases, I don't know if it was the Commission or the regulators, asked the company to modify, to amend the bylaws. In our case, regulators said nothing, okay? Just give us a deadline to correct those two situations, okay? So in this respect, the problem that we have, because as you can see in this slide, we are a listed company, and on the one hand, there's something that we may do, which is the fact that we may correct those two circumstances among us. It means that our board of directors may decide what to do. In this particular case, it's a matter of telling one of our members of the board, either you stay with us or you resign and stay with the company or undertaking acting in the production and supply sector. In the second case, it's a matter of telling the two of our investors, which by the way are banks, we may tell them that the board member that they have appointed may resign, or tell them to divest the investment they have already done in the production or supply sector. As you can see, those conditions are not that easy, but in a way, there's something that we can arrange among us. You know, we have 15 board members, and they may arrange this situation in order for us to get this diploma from our regulator. But the problem is not that. This is one problem, but the thing what we are now thinking is about the near future. And what about going forward? Because we are a listed company, and investors have the right to come and invest and to get a stake of 5% in our company. Do we need to change our bylaws, or maybe our internal rules governing the board of directors in order to give to third parties, to potential private investors, the certainty of knowing that if they come to us, maybe they wouldn't have the right to appoint a member of the board? Is this a real issue? Do we need to do so? Regulators haven't asked us to do that. Do we need to do that? Could it be unfair if we do not do that the investor come along in 5 years' time and says, here I am, I want a member of the board, I want to appoint a member of the board? Secondly, we're also thinking about the fact that, as I've already seen in other decisions taken by the European Commission, that a declaration on honor from the board of directors would be enough to show the regulators that we comply with the third package. Would it be enough if we get from our board of directors a declaration on honor that we don't give access to any other member of the board who may have an interest in the production or supply sector? Do we need to renew this commitment yearly, as long as the regulator has the right to come back to us to verify whether we comply or not with the third package? So these are some of the problems we are tackling nowadays. As you can see, we are an independent company in the sense that none of our of our investor may have control over us because it is not allowed under the Spanish legislation. We didn't have a big deal. It was not a big deal for us to get this conditional decision from the regulators, but we have the feeling that even though we are, an independent company who really are committed and devoted to guarantee independency and non-discriminatory third-party access to the network, we believe that maybe conditions adopted against us are a bit tough, given having in mind the fact that we didn't have the choice to choose among the three models, and given the fact that the first model we could say that is the best one. No, this is not the best one in terms of the third package, but we could say that this is the one, the more clear, the clearest one, in the sense that there's no cross interest, or we may not put in place a structure in the group which may guarantee independence among subsidiaries, like in the ITO model. So this is the reflection and my experience throughout this certification process that I wanted to share with you. That's all.
Thanks, Diego. Good. Thanks for being on time. We now start into the second part of session 1, which is the involvement of financial investors and how to ensure compatibility with the ownership unbundling requirements. We will have 2 presentations from my colleague Christian Hampel and Johannes Kindler in one go, and then we will have combined questions because the topics are very closely interrelated. And then we will have the views from the Commission, which are also, I think, very interesting to everybody, to us.
Yes, thank you very much for the invitation and the possibility of speaking here about this topic we have, which is unbundling and financial investors. It's a rather new topic, at least for financial investors, since it was hitting them a bit by surprise, so to say, and in the beginning, and now it has to be turned out to be a real problem for them. So in the beginning, I just want to make some words explaining that it's not only a problem to financial investors, but also to the development of the European energy market. Then I want to go on and explain something with regard to the special characteristics of financial investors and what makes them probably different from utility companies. Thereafter, I want to say something about the concept of control and what does it mean for the investments of financial investors. And then I want to make some suggestions for a reasonable or soft interpretation of unbundling rules, something what we covered already in the first part of the session this morning. So why it is important for this topic, not only for financial investors, but also for the energy market. I put on here some numbers. They are, of course, not complete with regard to investment obligations. These numbers only relate to networks. As you probably know, we do not only have to invest in networks a lot, but also in generation facilities. One reason for that is the 2020 agenda of the European Union. What we further see that this need for investments by financial investors is driven that the old, so to say, incumbent utilities companies are not able anymore to shoulder the necessary investments. And therefore, the financial investors come into the play, and they are, first of all, highly welcome. But as we see, there is a big change of uncertainty on the side of the financial investors, whether they are able to invest in generation and transmission assets at the same time. If you take unbundling rules literally, then you would say, as I explain later on, that if they have to decide whether they want to go into generation or they want to go into transmission assets, which would mean so there are less investments than there could be. So what makes financial investors special in comparison to utility companies? On this page I just try to give you an overview what financial investors are. Of course, we are talking about institutional investors, which can be very different from banks, insurances, pension funds, and so on and so forth. And then there is some differences with regard to the investment strategy. What we see in our practice is that the most important financial investors are infrastructure funds, and therefore I want to elaborate a bit more on their structure and what makes them special, maybe. So first you can see with regard to investment funds, there are two main entities. One is the infrastructure fund, holding the assets for the economic benefit of the investors. And the second entity is the investment manager, managing the investments. Very often this investment manager does belong to somebody else, for example, a bank. The investment manager is not only acting for one infrastructure fund, but very often for different ones. And this structure of infrastructure funds is achieved by a limited partnership, so the investors are the limited partners putting in the capital, and the general partner doing the management of management. So, and then the infrastructure fund itself is holding the portfolio company, which could be a generation company or a transmission company, for example. What's important is that in most cases the investors behind the fund have no influence on the choice or the management of the individual portfolio companies. This is done by the investment manager, of course, in the most cases, and also the investment manager has only limited influence on the day-to-day business of the portfolio companies. That's resulting from most cases from its structure, which are very, for example, limited personnel, which does not allow to go into the day-to-day business. The interesting case or the interesting question is, with regard to unbundling rules, maybe if we go back to the structure, is who has control over the portfolio companies? Are these the investors or is it the investment manager? If you go into the merger control rules, then you can see that in the usual cases, the Commission sees that the investment manager has control over the portfolio companies, not the investors. Of course, that depends on the how does the investment management contract looks like, so whether it can be terminated without any reason or not. But that's something for a case-by-case analysis. But to keep in mind, in most cases, the investment manager is the entity having control over the portfolio companies. Maybe what's important with regard to unbundling rules and financial investors is to say something about investment policy. As you probably know, unbundling rules are put into place for one reason is to avoid conflict of interest. Here you can see with regard to investment managers acting for several funds that they are obliged to do the best directed to every single fund. So they do not take they are not allowed to take an overall view on all funds. What's a problem is that what you all can also see, the management done by the investment manager is not separated between generation and network activities. But at the same time, you can say, due to the structure of investment structure funds, there is a limited incentive for synergies. And also what's important point is that due to the investment strategy, key point or keyword is diversification in that case, it's not about getting market shares, it's more about getting returns. So, and diversification means also that it's diversification relating to the place and also to the activity. So very often it's not a national strategy, but a European-wide or a worldwide strategy. And in addition, it's not only energy or electricity or natural gas, but in addition, these are other infrastructures, facilities such as ports, streets, tunnels, etc. Another important point is what you have, what is the intended corporate governance structure with regard to the portfolio companies. And there, coming from the investment guidelines, it's very often that it's said, okay, if you invest the money of the fund, you have either to have a majority holding or a minority holding with significant influence, which means that you have something to say on the budget and financial planning on a regular basis. And also what's very usual is that you are entitled to appoint a member of the management board or the supervisory board. Something I just want, in the interest of time, shortly to mention is to keep in mind with financial investors, it's that there is not only energy regulation, as you could think, but there's also finance regulation. Maybe something what is becoming very important in the future is this directive on alternative investment fund managers. And there, to make it short, one aim of this directive is that you want to prevent conflict of interest of the investment fund manager, so saying that he is only working in the favor of one fund, although managing different funds. The sad thing, or there's a problem with this, is it has to be transposed into national law only in 2 years, and then the rules, specific rules that shall prevent the conflict of interest, so they have to be detailed in the future. They are not detailed yet. So, and here it says European Commission to set them out in further detail. So, what's the problem for financial investors in regard to unbundling rules concept? As you probably all know, we have this concept of control, meaning that you are not entitled to have control over generation supply and at the same time over a transmission network. This applies across the electricity and the gas sector. So, for example, having a wind farm in Greece is not compatible with having a gas transmission network in Lithuania, at least if you take the unbundling rules literally. And then this concept is also further extended by putting in this exercising of any right. There are some examples in the directive, what does it mean? And the most complicated one, and that's something I think what we already discussed with regard to the Spanish TSO, is a power to exercise voting rights in the TSO. At least if you take the interpretive note of the European Commission as far as it stands, then you could say if there is a power to exercise voting rights in the TSO, then it's exercising any right which causes unbundling rules to apply. Then just one short thing here, you could think of, isn't there an exemption for financial investors? The concept of control is known from the EU merger control regulation, but the short answer, unfortunately, it's not, because the conditions for this exemption to apply are very restrictive, and here it's the most harmful thing is that you are not allowed to appoint management or supervisory board members. So therefore, in the end, that means you can only enjoy financial rights, but so receive dividends, but you cannot take part in decisions making process of TSOs. So and that's not what financial investors want to have. So what could be a solution for this? It's, I called it a reasonable, or you can call it maybe a soft interpretation and application of unbundling rules. For this you have to keep in mind what was the whole the whole aim or reasoning for ownership unbundling. And there it's quite interesting to look into the recitals of the directives, and there you will find something: ownership unbundling shall prevent integrated utility groups from discrimination with regard to network access, and also avoid conflict of interest between supply and network business. And then it goes further on, saying it shall incentivize to invest adequately in networks, and it even states ownership unbundling at transmission level is the most effective tool to promote investments in infrastructure in a non-discriminatory way. And another point besides the directives, what is very important, could be very important for a reason to a soft interpretation, is that what we have here with the unbundling rules in the directives, that's a restriction of fundamental freedoms under the EU treaty. And in particular, the free movement of capital and the free movement of establishment. That does not mean that unbundling rules are not legally, but if you have a restriction of those rights, then you can do it only if the application of such a restriction is or follows the principle of proportionality. That's something what we covered this morning already. So therefore we think, of course, there's room for interpretation and discretion for the national regulatory authorities, and also very important for the European Commission. In the next slide, I put on some examples. What could that mean, a reasonable or soft interpretation? I think in the interest of time, I just want to put them here as a question. So what could be the result of a soft interpretation? Maybe could we end up with an exemption for financial investors, at least where we have no conflict of interest? Would that be a possibility? What about the geographic reach of unbundling rules? Do we have to bother about generation facilities outside the EU? For example, Australia, or the example United States. In all cases, is it right to put electricity and gas activities on par? So meaning, example, wind farm in Greece and the gas transmission network in Lithuania, is that really a question for unbundling rules? Then something what we already have in the UK legislation is that we have a de minimis exception. Is that something what could be introduced on the European level as well? And then next, what's very important for financial investors and also for the energy strategy of the European Union, what about an exemption for renewable energies? So if we could talk about discrimination and conflict of interest in case of what we want to achieve is ownership unbundling, is it really necessary if we talk about regulated generation assets, which are in many countries for renewable energy sources? So that's just some question. Last remark, you could say, well, do we need all this interpretation of unbundling rules? Don't we have already a solution, the ITO option? Our answer thus far would be it's not an answer, at least not to all cases, because there are many questions coming along with the ITO option. The most important one, does it apply? As we have heard, it doesn't apply for new transmission assets. The question is, does it apply to all old assets, or does it only apply if it stays with the vertically integrated utility that it was, or that it belonged to already in September 2009? And also another point here is, of course, you can choose the ITO option if it's available, but then you have the question, it limits the influence of the shareholders. And as it is very often the case for financial investors, they cooperating with strategic investors, and strategic investors are very often set up as ownership unbundled. So, and they want, of course, do not want to have this restriction of an ITO model. So these are some points And in the end, what's the conclusion? And here I would say one very important point to keep in mind for investors is that we have a predictability that you can foresee what will happen. And I would say, or need to say, the current situation is not satisfying. And also, so that's one point. The second point is, I think to solve the problem, not only in the interest of the financial investors, but also of the European energy market, we need to have a reasonable interpretation, otherwise it will not work. And therefore, I would very welcome if there was a decision, or at least guidelines, or you can call it a new interpretive note from the European Commission that says what's within the unbundling rules and what not. And then maybe another idea in the interest of financial investors is with regard to the foreseeability. Now the situation is that you only know what's the result of all this if you apply for a certification. But of course, if you think about an investment, then the application for certification is only the last thing you will do. So maybe it would be worth thinking about some procedural enhancement allowing for a pre-clearance in interesting, or if there are interested parties, of course, under specific circumstances. Okay, that's for the moment. Thank you very much for your attention.
Okay, as indicated before, we won't have questions now, but Mr. Kindler is going to continue immediately.
So, Jean-Pierre and what is your first name? Christopher, sorry. Thank you very much for the invitation. For me, it's not only skin-warming to be here again, but also heart-warming. Okay. This presentation may have some similarities with the presentation of Christian Hampel, because you know, everything we can say is the result of normal thinking and common sense. Have a look on the EU energy infrastructure program. Mr. Oettinger believes that 1 trillion euro should be invested by 2020, and among others 200 billion in electricity and gas networks. I have certain doubts that all this money will be spent for several reasons we could discuss before, after the presentation if you like. But what is absolutely clear, it's a huge money. It's a huge amount of money. And it is a huge effort, not only for the financial sides, but also for the governments, the regulators, and the whole industry. Numerous TSOs obviously cannot shoulder the whole financial burden. And additional equity is needed. Who could provide this equity? It could be the state. Even in Germany, there are some political forces who are thinking about that. Or it could be state-owned investors the Temaseks from Singapore, ADIA from Abu Dhabi, the Norwegian Investment Fund, and so on and so on. Or it could be private financial investors. And I think they should have a reasonable chance to participate. And in this context, efficient financing is very key to limit the burden of industrial and private consumers. You know, everybody is talking about the discrimination of the consumers by financial investors. But if a financial investor brings efficient financing techniques and efficient management methods with him, it is also very to the sake of the customers. So Christian has described a lot of types of financial investors. This is what I would like to call a biodiversity of investors, which depends on the business objectives and the corporate structures, the investment banks, the Goldmans, the Morgan Stanleys, and so on. The insurances, it's not only Allianz, there are many, many insurances which are interested. We are just thinking about a very important American insurance. Pension funds, very important as well. Private equity companies, it will be probably less frequent. And citizen funds, what we call in Germany citizen funds, also the citizens of member states, which a certain income should have the possibility, the opportunity to invest, of course, with a very in the framework of a very serious structures. So I'm speaking also about developers. That is a completely new phenomenon, which is showing up in Germany. These people are organizing the building of the infrastructure, the financing, and they are able to organize the operating together with the TSOs. We are advising a client who is very seriously examining to invest a very considerable sum, a very considerable amount in offshore cables, a couple of billions. And this guy already has experience in building and operating of DC undersea cables. And he tells us that he can do it cheaper than the classical TSOs. Let's wait and see. We have got to know another investor, one of the biggest TSOs of the world, who has also a very serious experience in DC technology, and who would also like to sell DC technology, his DC technology, by his manufacturers. Very interesting. So, ownership structures, private funds, state-owned funds, and they are organized according to the framework, to the time frame, medium-term investors or long-term investors. Long-term investors are pension funds, insurances, which can invest so-called patient capital. All the investors have certain targets of profitability, they have a specific risk profile, and they are subject to specific regulation, energy regulation, which is very important, is the regulation which is called Basel III. It is aiming to limit the risks and to underlie the investment with a certain degree of equity. The same Solvency II, which applies to insurances. And of course, within the shareholder agreements, you find a lot of rules which are very determining for the investment. It's not only ownership unbundling. I think it's very important to know that. So the investment, what are the investment criteria? Christian described a lot of criteria, and I have said certification. I have mentioned certification. The normal regulator believes that it's to him to certify the investment. He's right. But what we should know is that our country, our member state, is scrutinized, and our investment is scrutinized, and at the end of the day, you get a certification of the investor or not. And so not only power producers should complete. The reality is that the states are competing for investors. So the key criteria is political stability, an investment-friendly climate, and an investment-friendly legal framework. The economic perspective of the relevant investment area. Will they have growth in the future? Which means will they consume more electricity and so on, which is enormously important and not only a question of money. The perspective of realization, the environmental legislation, the permitting procedures, the public acceptance. That is very important because the investor, and especially the financial investor, has to report to his investors why there are delays in the build-up of the infrastructure. Not only the government gets nervous about that, and the German government gets slightly nervous on what happens, for instance, in the offshore sector. For any investor, it's important to realize his investment in time. And if I had to advise the Commission, and when I was still a regulator, we discussed it often with our friend Katharina and the other colleagues of the DGN. If we don't manage to simplify the environmental legislation and the procedures, we will get a big problem in 2 or 3 years. So what is also important is security of the investment, protection against stranded investments or against a disruption of functioning. And of course, key is also the profitability of the investment, the relevant legal and regulatory framework, and of course, the tax situation. Profitability of the investment. You know, the normal sound you hear when you speak with financial investors, or when you spoke with financial investors, it's not, infrastructure is not profitable enough. We have alternatives. I think a couple of European member states have managed to establish a very interesting regulation and a very, very interesting financial framework, which is attractive and remuneration in the order of magnitude of 10 or 11%, which you can easily reach with a slight degree of leverage. It is very, very interesting and you know, there are not anymore much opportunities to get such a remuneration with a degree of risk which is very, very low. So you, if you speak to them, you can, I think you can be relaxed if your framework is adapted to the needs of an investor. So I have said what is also very important are the legal and regulatory constraints. Solvency II is a much bigger constraint to investor, or has been a much bigger constraint to investors than any ownership unbundling regulation. We should know that, and I tell it so broadly because it is also important for the conclusion we should draw at the end of the day. Full ownership unbundling, when I was a regulator, Mrs. Cruz sold this as a guarantee for investment and compliance. I'm not that sure, but it is, we will see what happens sooner or later. The whole system probably will be subject of an assessment. It's too early to give judgment. What is in any case true is when the third package was conceived, financial investors were not yet in the mind of legislators and regulators. The typical investors were the TSOs. And ownership unbundling and the whole regulation of Article 9 and the other relevant articles aims to avoid conflicts of interests and discriminations of users of the grid and so on. A conflict of interest, it's undeniable, may arise if a financial investor with generation activities tries to influence the operational management of the grids or the investment policy of the TSOs. And that is already, let's say, a serious, a serious perspective, but the situation becomes really unacceptable if this behavior enables the investor to generate advantages that an unbundled investor would not have. I think this should be the benchmark of our future reflection. This means that, in my opinion, the regulator should not be supposed to react to any potential danger. If you read the rules, you have the impression that a wind park operator in Greece who also owns a gas pipeline in Lithuania, that he is not compliant with the regulation. I think this guy is not a danger for the European consumer and so on. So Is full ownership unbundling a guarantee for investments and compliance? I don't know. Some people say yes, some people say no. In any case, if the regulator applies and decides on so fundamental consequences as the loss of voting rights, his decision has to obey to the principle of proportionality, and they must be weighted up against the freedom to invest and the free circulation of capital. Because no financial investor will accept to give up his fundamental shareholder rights, which protects his control over the investments. So what is the practical impact of Article 9 on financial investors? We think that's a problem, or I personally think that the problem is sometimes overestimated. Financial investors are normally not able or not interested to interfere in the operational grid management. Many investors are only engaged in project companies without significant influence to the mother company. And as I've said, ownership of transmission and generation capacities can only lead to abuse if they can be combined to influence the market. That's why the investor or the owner of a wind park in Greece and of a gas pipeline in Lithuania is not very dangerous. So, in my opinion, a solution could be that the Commission and the regulators develop a checklist with criteria to serve as a basis for an assessment of risks. For instance, the size and the importance of the transmission and generation activities. If you have 3 million windmills and 20 kilometers of cable in very distant area, it's not dangerous. Which is important, as I've said, the geographic proximity of the assets under the control of the same investor, and if a combined abuse is possible. If these criteria are fulfilled, there's an assumption of potential abuse, and the investor should be obliged to prove the contrary to the regulator. He has to prove his innocence. Thank you very much.
Okay, thank you very much for allowing me to make this intervention. I first want to say a couple of caveats. I now understand very well why my colleagues from the unit in charge of all these certifications sent me here instead of them. I've listened very carefully to all the questions and I've taken note of them, but I am not sure that I have the sufficient expertise to answer all the detailed questions. I see that there is a lot of challenging times ahead of us, but I also think that the Commission's views are evolving also when we see more certifications coming. To this one question on whether the ITO status could stay if the assets are sold, I think from the corridor discussions in Brussels, it's more that the answer would at this stage be no, that then in the future it would have to be fully unbundled. But of course we look forward very much to the German regulators' opinion on this, and as I said, our opinions at this stage are of course evolving, and we listen to good recommendations. Then to the subject on the unbundling or certification process and financial investors. I think we had two very good presentations on the issues at stake, also proposing some suggestions on way forward. I'm going to basically briefly explain to you where our internal discussions are at this stage. And again, I think it's probably very wise from my colleagues to send me here, because as I don't know enough, I am not able to say too much. And also, if I say something which is not correct, they can always say that I didn't know what I was speaking about. So with those caveats. So the question of financial investors and unbundling has, of course, emerged now that national regulators are in the process of certifying the TSOs, but also at the same time, as Mr. Kindler very well put it, we have a huge investment challenge ahead of us. So if we are going to make all the investments by 2020, as foreseen in the EU's infrastructure policy, we do need financial investors to help the TSOs in these investments. We have seen in several cases the TSOs needing to double or even triple their investment volumes, and that poses a challenge. Financial investors, of course, are keen to diversify their risks and therefore interested in investing in both transmission and production assets. We have been speaking with several financial investors. We have been speaking with several transmission system operators in preparing our approach. We have also worked very closely with the regulators, especially under the CEER task force, which is looking into these issues. So if we are strict lawyers, and of course in the Commission there are always strict lawyers, especially in the legal service, the interpretation of Article 9 is very clear. So no productive assets if you want to invest in transmission, be it in electricity or gas. I mean, this is the most strict interpretation which some of our colleagues are seriously proposing. However, I think what is important and what the two speakers before me and also in the morning mentioned is to see what is the intention of the legal text, what is the aim of Article 9, and why are we concerned or worried about financial investors in the context of unbundling discussions. So, and as has been said very well, I don't need to go into the details, it's that there should be no incentive to influence the decision making in such a way that the end result is not optimal. So proportionality has been mentioned. I think that is a key word in this context. We have been looking at the issues, we have been discussing the de minimis rules, we have been discussing block exemptions, etc. But we are currently of the opinion that a case-by-case analysis would seem to be the best way and closest to the spirit of the legal texts. In a case-by-case analysis, of course, the burden of proof is typically with the TSO in this case, who wants to have financial investors investing it or wants to invest itself in another TSO. So if we first look at some of the cases where the Commission has given an opinion to a certification prepared by the NRA, this gives already some ideas of what way could be the way forward. The first example I'm going to mention is the one of the national grid electricity transmission in the UK, where there were some productive assets also, but in the USA. And this, because of the geographical location, was seen as no problem. A second case we discussed this morning concerns sweet gas from Sweden. And there again, the limited amounts of production of electricity, especially during the summer period, was seen as not creating any problems. So again, the size of the assets, the amounts of production in concerned could give us guidance on how to assess cases. And the third and last case refers to Red Electrica from Spain, where the SEPI, the shareholder, which also controls certain generation activities, mainly coal-based, but very small size. Again, the Commission is of the opinion that there is not an issue there, but it is quite okay. So as a couple of practical cases where decisions have been taken already. In parallel, discussions are going on, as I mentioned, within the CEER task force, where a number of elements have been raised as could form maybe this guidance or checklist for regulators. One of these elements concerns geographical location. So we already mentioned, and has been mentioned by many, that transmission assets in Europe versus production in US or Australia is certainly not a problem. And we could there also maybe work more close by, not only looking at other continents, but maybe look into, it was mentioned, electricity in Greece versus gas in Latvia, for instance. That's an issue where more work could go into. Second element concerns the value and nature of the participation. So of course, if we have a very minor shareholding in productive assets against a major asset holding in a TSO, I mean, the sheer nature, the sheer size of these, of course, has an impact on whether there may be influence or not. So again, there on the size of the assets, that could be one of the guiding principles. Third one refers to the whether there is a possible impact on the wholesale price evolution of the asset holdings. So of course, if a financial investor wishes to invest in generation, production or supply, which are sensitive to wholesale price evolution, there could of course be more easily possibility to discriminate against actions. So again, an area for further exploration, the day-to-day operational activities and the link to wholesale price formation. Then the fourth one refers to the interests of other stakeholders. And it was already mentioned today that if an unbundled TSO buys a share in another TSO, if this, or if a certified TSO buys shares in another TSO, the risk, of course, should be seen as a smaller one and not in a similar way as the VIU case. So again, the structure of the ownership and the remoteness from the productive assets is of an interest. So this to give a couple of examples of the elements that such a guidance or checklist could include. These are of course non-exhaustive and further work will need to be carried out in order to be able to finalize something which is to be used. It is true that the Commission is of the opinion that any material changes in the production, generation or supply activities of the shareholders concerned, so of the financial investors, may trigger the need for the reassessment and recertification. And again, there possibly some thresholds or guiding principles would be useful in order not to not to have to do it too often. We have been discussing with regulators, asking their views on these ideas I just briefly described. We have basically received 3 types of feedback from the regulators we have discussed with or who have commented. There have been 9 regulators commenting. So the first group, which involves the regulators from the UK, France, Italy, Sweden and Belgium, clearly support a pragmatic case-by-case approach based on a guidance from the Commission. Of course, these regulators have made comments to improve the approach that I just described. A second set of regulators from Austria, the Netherlands and Poland seem to be a bit more cautious in their recommendations. I mean, they fully agree with the case-by-case approach, but they would prefer to leave more room of maneuver to the regulators, so not to have too strict guidance as a document and have more learning by doing and case-by-case interpretation possibilities. The German regulator seems to be of the view that the approach put forward is insufficient, especially given the investment challenge we are facing. The feedback we received speaks for a more structural solutions, even raising the possibility to reopen the unbundling provisions of the third package. I think this is where I can immediately comment, is that the Commission is certainly not willing to reopen any elements of the third package. This is certainly not the moment, and it would create more regulatory uncertainty that we feel than it would solve. So at this stage, we are of course still very much on the listening mode and speaking to both financial investors as well as TSOs and regulators, but it seems that we would be willing to go in the direction of the 2 main recommendations from the regulators. So towards a guidance document, sort of a checklist with the elements I briefly mentioned, but not going into too many details so as to leave interpretation and flexibility to the national regulators. We are still very much in the internal discussions at this stage. Our Commissioner, Mr. Oettinger, is very aware of the issues and the problems that financial investors seem to face, and he is really keen to find solutions. So at this stage, I'm afraid I cannot tell you more, not even on the timing. I think before autumn, nothing will happen from Brussels side, so possibly early autumn could be a feasible deadline on that. So thank you very much for your attention.
But I hope everybody has maybe had a chance to recover a little bit, and the energy levels will propel us through the afternoon, despite the warmth, although it is cooling down a little bit, I think, looking outside. So I'd like to move now into the afternoon session, the first of the sessions this afternoon, on the fascinating issue of the new energy infrastructure package. And I'm going to hand over to Jorge, I hope I say it correctly, Vasconcelos, who will be chairing it for us. Jorge is very well known in the energy field, having been a regulator himself, and continuing leading light, leading thinker in this area. So I'm sure that we're in very safe hands to discuss this fascinating topic. So please take the floor.
Thank you very much. I'm not so sure, but we will see. Just before we start this session, I would like to thank the invitation, and in particular to thank Nadia for kindly inviting me to share this session. It's always a pleasure to be here and to come back to Florence and to the Florence School of Regulation, which was invented more than 9 years ago, almost 10 years ago, in fact. And just before we introduce the speakers and the topic, the fascinating topic, as you said, of infrastructure, I would like just to make some brief remarks about the fascinating topic of this morning, which I found deeply amazing for me, and I wanted to share with you just some thoughts, because maybe they are also useful as a kind of framework for the discussions we are going to have this afternoon on other topics, on new topics. And frankly, when I was listening to the debate this morning, I went very biblical, and I was thinking about this psalm, you know, abyssus abyssum, because in fact we were talking about complicated things that are so complex that nobody knows exactly how to handle them now. And these complex things were created some years ago, well, basically with the third package in 2009, to address very simple problems. But sometimes we have this fascinating ability of making simple problems new complex problems. What I mean by this is that we were talking about all these possible scenarios and complicated cases that may arise when you look at the ownership structure of system operators. That's the problem, okay? So now, why are we talking about all this taxonomy of new entities and possible combinations and conflicts and so on and so forth? Because some years ago, the European Commission and the Energy Commissioner at that time, instead of facing the real problems and trying to find solutions for the real problems, decided to go through another way, surrounding more or less the main problem, because they believed that if ownership unbundling was implemented, all the other problems we had at that time, after 2003, would disappear, would be solved. Well, we know two things now. We know first that even if we had ownership unbundling, we still would have lots of problems that would not have been solved through ownership unbundling. And second, we know that because the strategy at that time was to focus only on ownership unbundling as the only solution and the only possible solution to all the problems we were facing at that time, and this was the object of a political negotiation, and as very often it happens when you have a political negotiation, the outcome is very different from the initial expectations. We have now to handle all these wonderful, fascinating topics that you were discussing this morning, but we have not yet, in fact, addressed the main issue, which was how to make sure that our national system operators were working together in such a way that both at the planning and operational phase of the process, we were optimizing the functioning and making the single market happen. I don't think that the metaphysical questions we were discussing this morning will bring us closer to these goals we had already in 2003 and even before, but we will see. Now, this remark, I think, is important because I wonder whether we are today, let's forget now about the history, but are we today addressing the real issues, or are we today talking about, you know, side issues just because we are not brave enough to face the real issues? My feeling, frankly speaking, is that we are again repeating the same mistake. We are not addressing the hard questions, and we are trying to find answers to the more softer questions. One of them being, of course, infrastructure. I know that this is a very unpopular statement that I'm making now, and that probably nobody in this room will share this view. Nevertheless, based on my perception of what the history of the internal market was and the discussions we had this morning, I think this is again what is happening. Now, I'm not suggesting that infrastructure or other topics are not important. Of course, they are important. They should be properly addressed, and that's what we are going to discuss this afternoon. But what I mean is that we should not lose focus from the major issues. And one of the major issues, one of the major contradictions we have nowadays is a contradiction between a market design that was invented and implemented some years ago, even if it's incomplete, to serve the purpose of creating a single, fully liberalized energy market in Europe, and the different policy objectives we have nowadays for 2020, 2030, 2050. And we have not yet conceptually bridged the two. We don't have really a good answer to show how moving from 2012 to 2020 and to 2050 can be combined in a coherent process. So we are trying to find answers to some problems, but if we do not address at some stage these hard fundamental questions, we may well end up with solutions for these questions that, again, don't bring us that much closer to the solution we had expected. So that's a kind of warning based on empirical evidence from previous processes we have seen in the past, and I'm very glad to be here between the Commission and the Parliament because obviously they will not agree with my remarks, and this will make the discussion afterwards more interesting for all of you. Well, having said that, I think that we have this afternoon a very good panel. I'm happy that Faye was able to join us this afternoon. We will just change the order of the speakers, so because Ulrike has to take a plan and has to leave probably earlier, so Katerina will start with about 20 minutes giving us the point of view of the Commission about this proposal for the infrastructure package. Then we will go to Ulrike. No? It's okay if you are the third one, but we'll go to Felix and then to Ulrike and then to Faye, if that's okay with you. So, Katerina, the floor is yours. Thank you very much for coming and for being the last speaker in the morning and the first speaker in the afternoon, which is a remarkable performance.
Thank you very much for these very wise introductory words. The energy infrastructure package is often called, not in the Commission, but from the outside I've heard, the 3.5 package. So not the fourth package, but the 3.5 package of the internal energy market, which I think is a clear recognition of that the infrastructure area with the challenges we have requires also special attention. So needless to tell you that the Commission has been very active since 2007 with various policy initiatives. They are just here for the record. And also I think needless to remind us about the importance of energy infrastructure in achieving a fully functioning internal market, in ensuring security of supply, and also in making sustainability happen. These famous objectives, internal market by 2014, renewables integration by 2020, and in between the ending of the isolation of certain member states by 2015. Also this slide, I think these numbers were presented this morning. They demonstrate the investment challenge in the next decade, allowing the EU to meet on the policy objectives. The share of grids, electricity and gas, out of this 1 trillion investment need is 200 billion, 2/3 in electricity and 1/3 approximately in gas. When we came up with these numbers for grids in 2009, I think, they were criticized a lot. Since then, I think they have been confirmed by very many different sources, and last but not least, by the ENTSO 10-year network development plans. So electricity is the bigger challenge, not only because of the renewables, but also because of the increasing electrification of our energy system. So this was a very brief introduction why the Commission proposed the so-called infrastructure package last October. The Commission actually addressed the 3 network industries, so transport, telecoms, as well as energy. All of these 3 sectors has what is called guidelines as the policy document, and they are brought together in the so-called Connecting Europe Facility, which is the financial regulation. The overall budget the Commission proposed is 50 billion for the 3 sectors, out of which 9 for energy in the next 7-year period. The aim of the infrastructure regulation in energy is to make sure that 12 so-called priority corridors and thematic areas will be implemented by 2020 by providing regulatory certainty and policy certainty for these investments to happen. So the infrastructure regulation is, in a way, combining the policy objectives and policy needs with what we call a toolbox that should enable these investments to happen. And in the toolbox, we have included measures on permit granting, a set of measures taking the regulatory incentives a step forward, and then last, financing. I will briefly go through these. So this is the structure of the regulation with chapters for each of the areas. On the slide, I've only brought the electricity priorities. There are 4 geographical ones. So Baltic Sea, around Baltic Sea, the BEMIP, the offshore grid in the northern seas, and then 2 north-south connections in Western Europe and Eastern Europe. Smart grids all over Europe, as well as the longer-term electricity highways, also potentially concerning the whole EU. The gas priorities are very similar geographically as these, and then of course we are pursuing the efforts in the diversification corridor of Southern Gas Corridor. Oh, they were here, sorry. So in addition to electricity and gas, we also have included oil and future CO2 transport networks in the regulation. These, of course, are very broad priorities, and they need to be translated into concrete action. So projects that would be called project of common interest, and this is to happen in the regional setting, bringing together all the necessary stakeholders, be they TSOs, of course, project promoters, regulators, and last but certainly not least, member states' representatives. The identification of projects takes place against criteria, where, as we are in the EU level, one of the most important criteria is that all projects would have to demonstrate that they concern at least 2 member states. The other criteria reflect the policy objectives, and there are a set of indicators in the regulation. We have also asked the ENTSOs to develop a cost-benefit analysis that would be applied by all project promoters and TSOs in demonstrating their added value. So the toolbox then, the first element in the toolbox is to make sure that the project receive the necessary permits in a swift manner, meaning that we ask the member states to establish a competent authority, which may also be called a one-stop shop, with different variants about their decision-making powers, and the maximum time limit for permits should not exceed 3 years. And this, of course, if we think of electricity permitting today, is a huge difference from the more than 12 years that is often, on average, needed. Of course, we want to make sure that also the environmental quality is respected, and there are, of course, then also obligations for the increased transparency and enhanced public participation in the process. The second element in the proposal concerns regulatory measures. So I already mentioned the cost-benefit analysis that the ENTSOs have been asked to work on, and both of them have already started working on the CBA. Based on this cost-benefit analysis, we have also introduced a concept which is called cross-border cost allocation in the regulation, which refers to situations when the impacts or the benefits of an investment are typically located more in another country than where the investment cost happens. So when there is dissymmetry between the costs and benefits. And in such a case, the neighboring country who benefits from such an investment would be called to contribute to the investment cost as well. Procedurally, it will be the national regulators that will look at the submissions from the transmission system operators, and in case of disagreement, then ACER would take a decision. On incentives, we have also reminded the regulators about the existing obligation to provide adequate incentives, especially in our case with respect to risks which are inherent to cross-border projects. There are examples in the regulation of potential incentives. We have also asked the regulators to publish their methodology on how they assess risks and how they provide incentives, based on which ACER is asked to provide best practice guidance. And the Commission, of course, keeps the possibility for guidelines if necessary. And then the third element, the last element of the toolbox, concerns financing under the Connecting Europe facility, where the Commission would be very keen to support the financial market, the financial investors, through what we call innovative financial instruments. These are not innovative instruments at all. I mean, they are innovative because the Commission has not used them before, but they are used in everyday life in the financial markets already. And this would mean to support equity and debt financing, possibly through guarantees, for instance. These are instruments that we have started working with, and there is some experience in other sectors in the Commission, not in energy though, except through the Margaret Fund. We are also keen to provide support to the projects that will be identified through studies, as this typically is the phase when the project is getting shape, and could also lead, of course, to the project not happening. So, and these typically are costs which are not always accepted to be included into the regulated asset base by regulators. When it then comes subsidies for works, there the regulation provides very strict rules in order to make sure that there is no public money going to investments that can be carried out without. So again, here the cost-benefit analysis will play a key role. The cost-benefit analysis will have to demonstrate that there are externalities or non-commercial benefits scrutinized by the regulators, and only in such a case we may consider providing grants for works of projects. So societal benefits beyond commercial benefits. So the interinstitutional discussions are ongoing, and we are very pleased to have, of course, Felix here to tell us about the Parliament's views. So I will not go much into the detail, maybe just a couple of words on the Council side. We have made quite good progress under the Danish presidency on the identification of projects and on the regulatory measures, and we are now moving to the permit granting measures with the Cypriot presidency. We have also started the implementation of the regulation in parallel to the interinstitutional negotiations, which is a challenge of its own. So basically working with a moving target. And we have called for the geographical groups to meet in order to start the process of identifying projects of common interest. I think it's very useful in the sense also that we can learn by doing, and it allows also those who are party to these negotiations to see what the regulation actually means in practice. So the timeline for this ad hoc preparatory phase is 2012, so we hope to finish, depending of course on the interinstitutional negotiations, towards the end of the year. The starting point for this whole exercise are the 10-year network development plans of the ENTSOs, where especially in electricity we have a very recent good quality 10-year network development plan as the starting point. As I think many of you have noticed, the Commission also organized a request for information for projects which were not in the 10-year network development plans, and we are currently requesting for further information on all these projects. The discussions in the regional groups will take place starting from the autumn, and the decision making in these groups today is the member state representatives and the Commission. But again, as I said, we are working with a moving target, and we'll have to adjust the approach depending on the interinstitutional negotiations and what comes out from there. So a very busy year ahead of us in this area, but I think we need urgent progress in order to have at least the minimum infrastructure in place by 2020. So, thank you.
Thank you very much, Katerina. I would suggest that you ask now some clarification questions only if there is need for clarification, otherwise that we combine the discussion at the end, since the four presentations are really talking about the same topic. So any clarification questions about this first presentation? Yes, please.
Project of common interest, sorry.
Okay, then we should move from the Commission to the Parliament. Felix, the floor is yours. Next, we have Acer, Fai.
Good afternoon, everybody. I'm going to be very brief. First, because I think I'm preempted. After all these useful things we heard, and the different perspectives from the EU institutions, from the national regulatory authority as well, I think there were very sensible comments also in the beginning by George, and whether we knew the problem, why didn't we do something earlier. I think this is where we are now, and I think the Commission's proposal adds a lot and will add a lot to the whole process. Why we didn't do it, it's probably because of the political compromises, but also because I think that sometimes institutional arrangements, the creations of new institutions like the agency and the European associations for the TSOs take some time. Not least, and so market integration and these institutional arrangements should somehow proceed together. One thing I would like to underline, starting, is that I think that these infrastructure proposals should not be read in isolation. They're not a separate proposal. I think they're complementary to the third package proposals, and we shouldn't be forgetting that, you know, there are many of the aspects in the third package that basically introduced for the first time the European network planning, with the 10-year network development plans, with the obligation of the agency to provide an opinion on those, taking into account the internal energy market objectives. So these proposals, in order to work in practice, should basically complement what is already in the third package and should be read together. Also, we shouldn't be forgetting that, you know, better use of existing infrastructure is equally important. And it's not always that we will solve the problems by building something new. So if you see, and I'm going to present briefly the role of NRAs and the agency in the energy infrastructure proposals, there are many things which, as I said, are complementary. For example, you've got in the project of common interest will be not in this first list, but in the future, a subset of the 10-year network development plan, and they will both be based on a CBA, cost-benefit analysis, which should be undertaken under a common methodology. Now, the new proposals are there, the Commission explained very well, to accelerate permitting, to enable the regulatory treatment, to facilitate the regulatory treatment, and also perhaps for some financial support. This I would like you to consider separately, because as the Commission has indicated, the eligibility for financial support is not something which is with the PCI label. It's something which is judged separately after a PCI label is given according to a set of different criteria, and if market approaches do not work. So, briefly, you will see that both the energy infrastructure proposals and also the relevant provisions of the 10-year network development plans in the third package, what they basically introduce is a bottom-up and top-down processes. Already in the third package, you had the notion of national investment plans, Ulrike has presented, and also regional plans, and also European dimension, which should be taken into account in the community-wide plans. And now, under the new proposals, you've got also the regional corridors. I don't refer here, obviously, to oil and carbon dioxide. I refer to the corridors and the thematic areas, which are relevant also for the roles of NRAs and the agency. Now, there is an important element which I would like to highlight, which is developing the tools on how to get this right. And one of the important tools, in our view, is the CBA methodology. That's a basic, major step that the proposals of the Commission bring, because the assessment of the cost and the benefits of a project will be on the basis of a harmonized methodology. And this, you will see in the proposals, is not only relevant for the selection of PCI, but it's also relevant then to the NRA's decision on incentives and to different steps of the process. Now, the text you're going to see and the relevant roles and responsibilities are very much based on the latest text by the Council. I would like to highlight that this is, of course, not adopted. I think that what Felix said, the number of amendments which has been introduced simply shows the interest and the anxiety of people to get this right. But this is very much based, and it's provisional, on the latest Council text. So within the 6 months, the ENTSO shall produce the methodology, which then is submitted to the Agency for an Opinion, to the Commission, and then eventually the ENTSOs adopt it. According to the latest Council text, also the Member States should be providing an opinion to it. the relevant negotiations in the Council provide a shorter period and provide, I think, also a new element, which is very good, a transitional period. What do we do in the transitional period? All this process will take 15 months. So the Parliament says, let's try to put something in place 4 months after the entry into force of the regulation, because this is very much important as the preparatory work has already started, as Katerina explained. Now, the CBA tool the CBA basically is a tool, and I just quote here the Council text, to assess the wider benefits of a project that may go beyond national borders. As such, it may also demonstrate to which countries would be the beneficiaries. But this is only one input to be taken into account when regulators discuss how costs should be allocated. Is this something new? It's not. ENTSOI has made big efforts to base the last 10-year network development plan, which has just been released, on which the agency should be providing an opinion soon, on the CBA. It has defined 7 benefit categories. It has defined also major impacts like, social environmental impacts, costs, the increase of grid transfer. But all this will be in the future more developed and based on a more harmonized methodology. This CBA methodology will also be relevant and applied to all future 10TYNTP projects. This will be after the 2013. What's the role of the agency in all this? We start with some regional input, and in my slides which follow, I will present how the regions make their first assessment. Now, the first element that we have is that the NRAs, at some point, we expect that this will happen around autumn, and if necessary, the agencies shall, well possible in the context of regional cooperation, check the consistent application of the criteria and the CBA methodology. This is within one region. The involvement of the agency, if necessary, well, we don't know what that means. It could mean that the agency intervenes as a last resort or upon the joint request of regulators. But this remains to be seen. We think that, subject of course to this legal text being adopted, we think that the agency at this level simply observes the process to ensure consistency, does not really have the role, stays with the national delegations, national regulators as well, but the agency plus the Commission, as the Council has identified, should strive during this whole process to ensure consistency between the groups, exchange information, make sure that the criteria are applied consistently. The final decision on regional projects is done by consensus, Member States and the Commission, and then this is given to the agency, which needs to provide an opinion, and that is for the consistent application of the criteria across the region. And you've got here, more or less, a more, let's say, European dimension. We are now at the process from the regional input to try to create a union list. Now, the agency has to provide its opinion within the 3 months. The adoption then of the lists should take into account both the NRA's opinions and the agency opinion, and how it's done, basically by delegation of power. It still needs to be discussed by delegation of power to the Commission. All the projects of common interest should comply with the common, objective and transparent criteria that Katerina previously presented. A new element which was introduced on the latest Council text is that the regional groups should behave themselves and should take into account that the total number of projects should not be exceeding a number. Now, in the original Commission's proposal, this number was 150. Now, in the latest Council text, it's 250. And that the Commission then, when adopting the list, should ensure the cross-regional consistency, should ensure, of course, that the PCI, the project of common interest, fulfill the criteria, take account of the agency opinion, and aim not exceeding of the total number of projects. After a project is given the PCI label, we pass to the complexity of the regulatory treatment and the cost allocation, and also the incentive regime that Ulrike previously presented. Now, when a PCI is sufficiently mature, an investment request as well as a cross-border cost allocation request is submitted to the concerned national regulatory authorities. This should be accompanied with a CBA, consistent with the common methodology, and a business plan to evaluate the financial viability of the project. Why is this introduced? Because you will see from the Commission's proposal and the latest negotiation that only efficiently incurred costs shall be borne by the TSOs or the project promoters, and those which basically are based on a net positive impact, to the extent, of course, that these are not covered by the other charges, like congestion charges. Now, there, the relevant NRAs should jointly reach a decision on the allocation of the investment costs to be borne by each system operator and their inclusion in the tariffs. They may decide to allocate only part of this cost, and this decision is notified to the agency together with all information, and it's published. Now, one interesting element of the latest Council text, which is also, I think, relevant to the presentation previously made, is that now it's very clear in the text, is that when deciding on a cross-border cost allocation, the national regulatory authorities should ensure that its impact on national tariffs does not represent a disproportionate burden for consumers. What does that mean? I cannot tell you, but actually it shows the complexity, which I think was evident from the previous presentation, in trying to make an assessment on enabling the investment, but on the other hand, protecting the consumer. If now the NRAs do not agree, the agency intervenes, and the agency has to reach this decision on the cost allocation, the inclusion in the tariffs. The agency has 6 months to agree. If they don't, the agency takes over and has to reach a decision in 3 months. Now, this is not a new element. Those of you who have read very well the third package, you will see that there are already provisions there, but of course with very longer, let's say, time frames. So in a way, although in the third package this provision was that the NRAs could have 6 months and then another 6 months, and then the agency's opinion should be provided in a longer period, now we've got an attempt to accelerate this. Then there are provisions on incentives, which again are not new. The existing internal energy market legislation provides that tariffs for access should provide incentives for investments. And the new proposals on energy infrastructure describe how this is done, when a project incurs higher risks, then the NRA should ensure that incentives are given. Now, the first stage of the process is that when this is available, the NRA should submit its methodology and criteria used to evaluate investments in transmission projects and the higher risks, so to allow the experiences exchange and the best practices. The agency should also facilitate the sharing of best practices, both on incentives and the common methodology to evaluate the incurred higher risks of investments. Then the NRAs should publish their methodology and criteria. If all of these measures are inefficient or not sufficient, then the Commission may adopt guidelines. The last stage is the monitoring of implementation. And this is based on the project promoters who draw up implementation plans and provide for annual reports to outline the progress achieved and the time schedules considered. On the basis of this report, the agency provides a report on how this is progressing and makes recommendations if appropriate. Now, a lot of preparatory work has started. This is for for congratulating the Commission, because I think that by putting together all these regional groups meetings, people start thinking a bit in the context of these new proposals, although these have not been adopted. You will see this which is the calendar of the corridors meetings. I just present this to show that a lot of activity goes ahead and a lot of things are happening. Now, as the Commission presented, the Commission has asked for applications, separately also for non-TY and TP projects. And now also the questionnaires have to be filled in and completed and taken back to the Commission. And the calendar is broadly that more information for all projects should be submitted to the Commission by 19th of July. There is a big info day which the Commission is organizing for informing about the process and the PCI lists, and a public consultation which is already there, launched on the 21st of June until the 20th of September. So this is again for the public consultation. The lists which are now submitted to the public consultation have not been subject to any screening or pre-selection. It's just all the applications. Now, groups have already been discussing on a more informal basis. They have agreed the weighting of their criteria. The projects are grouped according to a common method of ranking. And the groups themselves give consideration to the criteria and the weighting, the urgency, the number of member states affected, the complementarities, and this is to be done, probably in October. Then the groups, as I said, need to behave themselves and try to take into account that the whole union list should be, not more than 250. This is where we've reached. My presentation will be available. There are now many discussions. The last Florence Forum discussed energy infrastructure proposals. They invited the ENSOs and the agency to outline their common methodologies for a consistent framework for PCI. As I mentioned previously, the CBA methodology is not there, and we need to start developing the tools and some reference to ensure consistency, as the group's preparatory work is already going. We have, and you will see soon in our website, a midterm review of the agency's work program for the 2012, and there we take into account of all these energy infrastructure proposals requirement. And finally, the 2013 work program, which again is going to be published now, I think it should be published today actually, provides for starting of work for harmonized transmission tariff structures in the electricity, because on gas, much work has been done on framework guidelines on tariffs. We'll be discussing that in July. We will be having, of course, all these elements that I previously presented, the opinions on the methodology and the consistency of the criteria, the guidance on incentives, and of course, trying to facilitate the cooperation of NRAs. Again, what I would like to just convey is that these proposals, and the Commission is very much I think to be congratulated for tabling these proposals, are complementary to existing legislation, the third package. To make this work, we should make this work as a package. Thank you.
Hi, ladies and gentlemen, welcome to the final session on the elusive subject of REMIT. And we have here to chair the session Mr. José Bratz from the Portuguese regulator, who I think is also chairing the CER group, working group on REMIT, another area that perhaps raises often more questions than answers. And that's why we hope to have two presentations. Unfortunately, one has not been able to attend for the industry view, but that has an advantage for us that we can field a lot of questions. So I turn the chair over to Mr. Bratz.
Thank you, Lee. First of all, thanks to the organizers, to BNetzA and to the Florence School for inviting us to present some views on REMIT. I think it was very courageous from the organizers to put three hot topics on a hot Florence day. But it's been very instructive so far, and I'm sure that this last session will also be interesting. Our time is short. We have a little more than half an hour, so I'm going to ask our two speakers to be fairly succinct and to the point. Just as a quick word of introduction, and the fact that we don't have someone from EFET here means we want to leave as much time as possible for the discussion, because we want to get your views also on this topic, which is another aspect of the principle we've heard mentioned a few times here today of the proportionality between the scale and the weight of the remedy versus the objective. As the name implies, REMIT is the regulation on market integrity and transparency. So of course it's about markets functioning better, and it's anti-abuse, but it's mainly pro-market. And the balance that we need to attain is, on the one hand, to make sure that it works in the sense of being conducive to more transparent and integral markets, but on the other hand, we have to make sure that the costs of achieving this are not so high that they end up being sort of counter to the existence of the market. We do not want market players to be the healthiest corpses in the cemetery. We have to find a balance that allows us to achieve the objectives without being so heavy in terms of costs and bureaucracy, etc., that it in fact removes some players from the market. So with that in mind, let me turn over then to Fadel Lakoua, who is the deputy chair of the the MIT, the Market Integrity and Transparency Working Group in SEER and ACER. The way that we've gone about working on REMIT, which is quite recent, as you know, it's been in place since the end of last year, and because of the resource constraints in ACER, because ACER is the main sort of implementing body for REMIT, a lot of the work has been done in the working groups where the regulators provide the bulk of the workforce. So we have an MIT working group in SEER and an MIT working group in ACER, and of course some staff members from the agency itself, as is the case of Volker, who is second in line. But to give you the perspective from the side of the regulators, I will ask Fadel to, in 10 minutes or less, give us his presentation so that we can have time for discussion before closing time.
Okay, thanks a lot, José, and I'm very glad to be here today. As José mentioned, REMIT is a hot topic during a hot day, so during the Q&A session later on, if you see me sweat, it's because of the hot weather, not because of the question, hopefully. Anyway, so what I plan to do today is to give you a perspective from an NRA. So I'm talking here not in my capacity, as José reminded kindly, of Vice Chair of the MIT Working Group, but as Director of Financial Affairs and Wholesale Market Surveillance of CRE. Market surveillance, which has been performed by CRE for 6 years now, since the law of December 7, 2006. We reminded here the text of the law as it is written. We check the consistency between transactions and technical and economic constraints. So perhaps that's a key point here. When we perform our market surveillance analysis at CRE, we are consistently trying to check this idea of consistency between the fundamentals of the energy sector and the transactions as they are done. And I really want to insist on that. I think it's there you find what is today the spirit of REMIT, which is putting a tailor-made framework for market integrity, which takes into account the specificities of the energy sector. And one of these key specificities is that information related to physical assets, to production plants, say, are very important to have and can have an important impact on prices. So that's the typical example of price-sensitive information. So trading based on such price-sensitive information, if you have them and nobody else knows them, may be considered as insider trading, a concept that you find in the financial sector regulation, but that had to be adapted to the energy sector. And probably Johannes, which I see standing down there in the room, who is one of the fathers of REMIT, won't contradict me by saying that the spirit of REMIT is really into taking the specificities of the energy sector. Since the end of 2010, we also monitor carbon transactions which are done by participants who are active in the French wholesale electricity and gas markets. I can elaborate on that later on. I just want to mention at this stage that this competence that was given to CRE and also to the financial regulator to regulate the French carbon exchange, BNetzA, was a proposal in the beginning to be done at the European level, and the French government decided to implement such an approach at the national level before being generalized at the European level. The European Commission considered three options: doing something along the line of the French example, so something tailor-made involving both the energy regulator and the financial regulator, or including it directly into REMIT, second option, or third option, including the carbon sector into the financial regulation. And what is currently the privileged option considered by the European Commission is to include carbon sector into the financial legislation, so in particular considering the carbon as a financial instrument. Now, even if that option is ultimately taken, I think one of the building blocks of the idea of involving the energy regulators and the financial regulators is still there. If you look at Article 1 of REMIT, for instance, you'll read that ACER has to monitor wholesale energy markets and also take into consideration the interdependencies with the carbon market. So you have that idea there, and we know also that ACER will be ultimately collecting transaction data on carbon once they are collected by the regulators, most probably the financial regulators. So that's about our competence into carbon, which I can summarize it as something that came to complete our competence on wholesale energy surveillance. A key byproduct of our new competence on carbon was the principle of cooperation between CRE and the French financial regulator, AMF, which came by the same law that gave us competence on carbon, so the law that passed on October 2010. We signed an MOU in December 2010, which is publicly available. The interesting feature of our cooperation is that it is not only limited to carbon, but it is broader, and it covers electricity, gas, and CO2, both derivatives and underlying physical products, meaning spot products. So we're not the only ones. I know that in the Iberian Peninsula there are similar agreements. The interesting feature of ours is that it is comprehensive. It is not limited to electricity or gas. It covers everything in the energy sector, including CO2 and both the financial instruments part, so derivatives, and the non-financial instruments, which belong to REMIT now. And the key point of our cooperation, which has been living now for almost 2 years, which is to try to build on the complementarities between the sectoral approach linked to fundamentals and the financial approach. That's really very important. Sometimes we realize that when we are thinking about an issue, similar issues can arise in the financial sector, so we do not need to reinvent the wheel, and we have this partnership that allows us to speed up the thinking or whatever on approaches, on issues that have already been dealt with in the financial sector. And the reverse, when the financial regulator is I don't know, looking at something that is happening on an MTF, for instance, Power Next Gas Futures is an MTF, so it is regulated by them. They will clearly rely on us to the understanding of the product that is being traded on this MTF. So we try to concretely make it this way. Teams talk to each other regularly, building on the complementarities between the two expertises. Data collection, you can do market surveillance without having data, so it's a prerequisite. It's a prerequisite in REMIT, and probably Volker will talk about it. We privileged a centralized approach to data collection. The table here summarizes the data we get, so I won't go into the detail. I will only say that we collect both trading data, so that's individual trades made by companies, as well as fundamental data. So that's really very important. Our data collecting routines work on two legs. One is trading, one is fundamental. For both, we privilege a centralized approach, meaning getting data from exchanges and brokers instead of from individual market participants. And the same for fundamental data. We get data from TSOs, nominations, schedules for electricity production, etc. We get that from the TSO. The only exception to that, which is an unfortunate exception, is the data collection scheme we put in place for the carbon. We privileged the same way a centralized approach, and we do already have information from in a centralized way, in particular from BlueNext and from the German exchange, EEX. But not all market venues, when we contacted them, accepted to do that. So we had to rely to a bilateral exchange in the beginning. We did it for the year 2011. Sorry. It's an interesting process. A lot of anecdotes and jokes to be said on that. I won't have time now, but if you ask me, I will tell you a couple of them. To conclude, I will simply give you an example of typical occurrences where we run an investigation. We have at CRE an internal discipline which is to systematically run an investigation in case of a significant price market event, and price spikes in electricity are a great example of a significant price event. We spotted here the spot electricity price in France, and we on the left side of the chart we had the price spike. You see on average the price reached 600 euros. For 4 hours the price reached 3,000 euros, which was the technical ceiling of the exchange. And on the right side of the chart we had a price spike which is more recent in February 2012. You might recall that it was very cold in that time. The funny thing about price spikes is that you always find a mixture of fundamentals, tension between supply and demand, it was very cold, but also operational issues, perhaps some transparency issues, and perhaps the way that individual market participants did their trading decisions. On the first price spike, the one that occurred in October 2009, the big issue that CRE insisted on was transparency. There was not enough transparency at the time in terms of, for instance, publication of outages. And a number of them happened during that time and weren't known by the public. So we insisted a lot on that. And that was a kind of soft law, but without any binding text, and I think the transparency guidelines on electricity or gas are still under the comitology process, so not enforced yet. But in France, that event triggered, and the fact that CRE insisted a lot on that issue, triggered significant progress on that area. And today, for instance, you have publication within 30 minutes of unplanned outages in the electricity sector as a significant example. Our latest deliberation on the price spike that occurred in February 2012 was released in May of this year, and it's available on our website in English also. So it can give you an idea of the findings we had. Same thing on gas. We looked at price spikes. The one that happened on this chart left side earlier in 2008, and the most recent one on the right side, again when it was very cold in February. Our deliberation on this latest one should be on the website this week. It has been approved last week by the Commission, and there the conclusions that we draw are mostly market design type of thing. So that's illustration of the fact that market surveillance can also feed the reflection from a market design point of view. To conclude now, I see the time running. Just perhaps the key factors of success from the experience we have at CRE. First one, operational aspects and data collection. So it's very important, and it should be as smooth as possible. The industry might be asking a lot of questions sometimes, and when things are working in practice, especially when it's centralized, it's not so difficult, at least by our experience and at least given the size of the French market. Second factor of success, fundamentals. Again, I think that's one of the key spirits of REMIT. So mixing both the trading, monitoring, and in conjunction with fundamentals is really key. And finally, we think that energy regulators should also talk and discuss, and perhaps more than that, with the financial counterparts. There is no need to reinvent the wheel, and I think this idea of cooperation is embedded in REMIT already. Acer can discuss, and with ESMA, for instance. It was already there with the third package, and I think that's also a key part of what hopefully will be a successful implementation of REMIT, and as Jose mentioned, to the benefit of the market. Thank you.
Thank you very much, Fadel. If I can ask Volker to give us a short presentation. Hopefully still leave about 10 minutes for discussion. Once we get the...
Yeah, just to introduce myself, my name is Volker Zuleger. I'm working for the Agency for the Cooperation of Energy Regulators as a seconded national expert, seconded from the Austrian energy regulator E-Control. Thanks for the invitation. Happy to be here today. I have to say I'm not only sweating because of the weather, but also because of the challenge we have with REMIT and the work that we have achieved so far, but also the work that is still ahead. I think I don't have to add much more because Fadel already has given a blueprint of how the work of ACER should look like in future. Because the initial idea of ACER, as seen in the name of ACER, Agency for the Cooperation of Energy Regulators, does not anymore apply here. The original role of purely coordinating is added in the new context of REMIT, a new task of REMIT, by the task of also monitoring and also data collection. And here I think it's important to highlight that ACER is even ahead of financial regulators because if you compare, for instance, now the review of MiFID and MAT, or MA and MiFIR, the two regulations that will be created out of MiFID and MAT, the Market in Financial Instruments Directive and the Market Use Directive, there ESMA doesn't have a monitoring role and no data collection role. That is still done at national level. Whilst here, under REMIT, for the energy market, we already have a monitoring role, a genuine monitoring role for ACER at European level, and a data collection for ACER, a central data collection at European level. Simply quickly, the three pillars of REMIT. There is, first of all, a definition of market abuse and market abuse prohibitions. The insider trading is prohibited and market manipulation is prohibited. The role model was here the Market Use Directive of the financial market with some tailor-made adaptations made to the energy sector. The second pillar is a market monitoring, and as I said, ACER will have a genuine market monitoring role and a data collection role, and cooperate there closely also with national regulators. And the third pillar is the investigation and enforcement at national level. That is a role that remains totally at national level, and where ACER has only a coordination role, however with the possibility to also foresee investigatory groups in cross-border cases. If we come then to the monitoring role that is foreseen for ACER, I think this is a nice picture highlighting also the complexity of the monitoring that ACER has to perform. It's not only that there is a starting role here with the monitoring of ACER and the initial analysis of ACER of any potential breach of market abuse provisions, but if there is any suspicion, then the case would be transferred to the National Regulatory Authority if it is an energy case, a clear energy case. However, often you may have also effects on financial markets, and if this is the case, ACER would not only have to inform the national regulator, but also ESMA at European level, so that ESMA can then involve the national financial regulator. If it is then also involving competition authorities, ACER also could involve DG Competition, or at national level, the National Regulatory Authority could involve the National Competition Authority, let alone in cases where there are member states deciding to have the monitoring of remit tasks at so-called market observatories that are maybe even placed at competition authorities. As you know, there is such an exemption foreseen in remit that may especially be applied in Germany, and in that case it's a question how ACER can also coordinate competition authorities taking care of competences under remit. If there is a cross-border case, as I mentioned, there are then the possibilities of investigatory groups, and it's interesting here that the investigatory groups may not only involve energy regulators, but also financial regulators and competition authorities in order to ensure that all aspects of a case are taken into account. Coming maybe quickly to the ACER work, and I'm happy that we can already show what we have achieved there with a small team at ACER, but maybe a small team is also advantages, but of course also with the work and the help of the ACER MIT working group chaired by José and co-chaired by Fadel. So as you know, there was the first ACER guidance on the application of definitions of remit that we issued already in December 2011, so before the entry into force of remit. We will have a public workshop on the second edition of the ACER guidance on 19th of July 2012 in Ljubljana, and by September we are planning to have a second edition of the ACER guidance, taking into account now also questions put forward by industry, by stakeholders since the entry into force of remit. So the second issue that we already achieved is the registration format. As you know, there is a registration foreseen in remit of market participants that have to register at national level with the national regulatory authorities. For that, ACER has a task to define a registration format in order to harmonize the registration at European level and to have all the data available for the monitoring exercise. We achieved by 27th of June, 2 days before the deadline of remit applied, that this format is published. There was public consultation between April and May, and also public workshop with stakeholders on that topic. And finally, we most recently issued another public consultation on our recommendations on the implementing acts. ACER has a possibility to give recommendations to the Commission on the record of transactions and the implementing acts for the data collection. And on 21st of June, we issued this public consultation. It will run until end July, and where we also foresee a public workshop on 19th of July in Ljubljana. By September 2012, we want to give the recommendations to the Commission. We are here in line with the work of ESMA on the EMIR data collection, the European Market Infrastructure Regulation, that will most likely collect most derivatives. As you know, this is a regulation for derivatives regulation, clearing of OTC derivatives, but also reporting of derivatives to so-called trade repositories, and most likely ACER will benefit from the collection of trade repositories also for the purpose of remit. I have here some more details on the public consultation document. So it concerns the records of transactions, so the fields for the data collection where we distinguish between standardized and non-standardized contracts. I don't go too much into detail because we are running out of time. The second issue is that we consider a list of contracts to be reported as foreseen in Article 8 of remit. The implementing acts have to list the contracts to be reported and the derivatives to be reported. We make some proposals on this topic as well. There are some rules on options for a de minimis threshold, especially for renewable producers. There are some de minimis proposals foreseen. 3 options are proposed where we are looking for the input of stakeholders. And finally, we also foresee some proposals for reporting channels. The idea is that reporting should be done namely through intermediaries, so-called registered reporting mechanisms, a role model that we have seen in the financial market, also trade repositories as for instance foreseen under EMIR. Then there are issues of unique coding for identifying market participants and other issues that are also tackled or addressed in this document, in this public consultation, including then also the reporting of fundamental data, of course. And to finalize the way ahead, as you know, REMIT already entered into force on 28th of December 2011. The provisions and obligations are applying for industry. Since then, we are relying mainly on the monitoring from national regulatory authorities like France, like in Portugal, Spain, and Italy, where this monitoring already applies. The data collection will apply 6 months following the entry into force of the implementing acts by the Commission, which are currently foreseen to enter into force mid-next year, as announced by the Commission, but we have to see whether that is really reasonable. And within 18 months of the entry into force of REMIT at national level, all the competences of national regulators have to be implemented, including sanctions of the breaches of these provisions and obligations. Thanks for your attention and looking forward to any questions.